Please be seated. The record will show the presence of the jury, the defendant, and all counsel. All right, ladies and gentlemen, the bailiff will give each of you a copy of the final instructions. The copy you receive is your copy. Feel free to make any notes you would like on your copy. Your copy will be shredded at the end of the trial. After each of you receive a copy, I'm going to read these instructions to you. Looks like we need one more copy for juror number 2. Does everyone have a copy? Page 2. It is your duty as a juror to decide this case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole fact. You must not be influenced by sympathy or prejudice. You must not be concerned. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. In their opening statements and closing arguments, the lawyers have talked to you about the law and the evidence. What the lawyers said is not evidence, but it may help you to understand the law and the evidence. During the trial, the lawyers are permitted to stipulate that certain evidence exists. This means both sides agree the evidence exists and is to be considered by you during your deliberations at the conclusion of the trial. You are to treat a stipulation as any other evidence. You are free to accept it or reject it, in whole or in part, just as any other evidence. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility she is not guilty, you must give her the benefit of the doubt and find her not guilty. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. You must decide whether the defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce any evidence is left to the defendant acting with the advice of an attorney. The defendant's decision not to produce any evidence is not evidence of guilt. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial, or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. The state has charged the defendant with certain crimes. A charge is not evidence against the defendant. You must not think that the defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may infer or find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence, regardless of whether it is direct or circumstantial. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it, in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Evidence of other acts has been presented. You may consider these acts only if you find the state has proved by clear and convincing evidence that the defendant committed these acts. You may only consider these acts to establish the defendant's motive, intent, preparation, or plan. You must not consider these acts to determine the defendant's character or character trait, or to determine that the defendant acted in conformity with the defendant's character or character trait and therefore committed the charged offense. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. You must evaluate the defendant's testimony the same as any witness's testimony. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. Count 1 charges the defendant with first-degree murder. Arizona law recognizes two types of first-degree murder: premeditated murder and felony murder. The state has charged the defendant with both types. The crime of first-degree premeditated murder requires the state to prove the following. Number 1, the defendant caused the death of another person, and 2, the defendant intended or knew that she would cause the death of another person, and 3, the defendant acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she would kill another human being, and that, after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. While reflection is required for first-degree murder, the time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The crime of first-degree premeditated murder includes the lesser offense of second-degree murder. You may consider a lesser offense if either 1, you find the defendant not guilty of first-degree premeditated murder, or 2, after full and careful consideration of the facts, you cannot agree on whether to find the defendant guilty or not guilty of first-degree premeditated murder. You cannot find the defendant guilty of any offense unless you find the state has proved each element of that offense beyond a reasonable doubt. The crime of second-degree murder requires proof of one of the following. 1, the defendant intentionally caused the death of another person, or 2, the defendant caused the death of another person by conduct which the defendant knew would cause death or serious physical injury, or 3, under circumstances manifesting extreme indifference to human life, the defendant recklessly engaged in conduct that created a grave risk of death and thereby caused the death of another person. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. The difference between first-degree murder and second-degree murder is that second-degree murder does not require premeditation by the defendant. If you determine that the defendant is guilty of either first-degree murder or second-degree murder, and you have a reasonable doubt as to which it was, you must find the defendant guilty of second-degree murder. If and only if you find the elements of second-degree murder were proven beyond a reasonable doubt, you must then consider whether the homicide was committed upon a sudden quarrel or heat of passion resulting from adequate provocation by the victim. Adequate provocation means conduct or circumstances sufficient to deprive a reasonable person of self-control. Words alone are not adequate provocation to justify reducing an intentional killing to manslaughter. There must not have been a cooling-off period between the provocation and the killing. A cooling-off period is the time it would take a reasonable person to regain self-control under the circumstances. If, after finding the elements of second-degree murder were proven beyond a reasonable doubt, you also unanimously find beyond a reasonable doubt that the homicide was not committed upon a sudden quarrel or heat of passion resulting from adequate provocation by the victim, then you must find the defendant guilty of second-degree murder. If, after finding the elements of second-degree murder were proven beyond a reasonable doubt, you also unanimously find beyond a reasonable doubt that the homicide was committed upon a sudden quarrel or heat of passion resulting from adequate provocation by the victim, then you must find the defendant not guilty of second-degree murder, but guilty of manslaughter. If you determine that the defendant is guilty of either second-degree murder or manslaughter, but you have a reasonable doubt as to which it was, you must find the defendant guilty of manslaughter. The defendant cannot be guilty of both second-degree murder and manslaughter. As stated earlier, count 1 also charges the defendant with first-degree felony murder. The crime of first-degree felony murder requires the state to prove the following 2 things. 1, the defendant committed or attempted to commit burglary in the second degree, and 2, in the course of and in furtherance of committing burglary in the second degree or immediate flight from it, the defendant caused the death of any person. An attempt requires the state to prove that the defendant intentionally did something which, under the circumstances she believed them to be, was a step in a course of conduct planned to culminate in the commission of the offense. The crime of burglary in the second degree requires proof that the defendant, 1, entered or remained unlawfully in or on a residential structure, and 2, did so with intent to commit any theft or felony therein. Residential structure means any structure, movable or immovable, permanent or temporary, that is adapted for both human residence and lodging, whether occupied or not. Intentionally or with intent to means with respect to a result or to conduct described by a statute defining an offense that a person's objective is to cause that result or to engage in that conduct. There are no lesser included offenses for first-degree felony murder. In order to find the defendant guilty of count 1, it is not necessary that you be unanimous with respect to whether the defendant is guilty of first-degree premeditated murder or first-degree felony murder. The only requirement is that you be unanimous that the defendant is guilty of first-degree murder, which can be either first-degree premeditated murder or first-degree felony murder. If you find the defendant guilty of first-degree murder, you must indicate on the verdict form how many of you have found the defendant guilty of first-degree premeditated murder and/or first-degree felony murder. By way of example only, the jury can be unanimous as to both theories or just one theory, or it may be divided. A defendant is justified in using or threatening deadly physical force in self-defense if the following two conditions existed. 1. A reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent, attempted, or threatened use of unlawful deadly physical force, and 2. The defendant used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in self-defense only to protect against another's use or apparent, attempted, or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use or threatened use of unlawful deadly physical force. You must measure the defendant's belief against what a reasonable person in the situation would have believed. A defendant has no duty to retreat before threatening or using deadly physical force in self-defense if the defendant, 1, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and 2, was not engaged in an unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. If there have been past acts of domestic violence against the defendant by the victim, the state of mind of a reasonable person shall be determined from the perspective of a reasonable person who has been a victim of those past acts of domestic violence. Domestic violence means any act that is an offense, including assault, aggravated assault, threatening and intimidating, endangerment, sexual assault, or unlawful imprisonment, committed while the victim and perpetrator are in a romantic or sexual relationship. The following factors may be considered in determining whether the relationship between the victim and the perpetrator was or had been a romantic or sexual relationship. A, the type of relation, determining whether the relationship between the victim and the perpetrator was or had been a romantic or sexual relationship. A, the type of relationship. B, the length of the relationship. C, the frequency of the interaction between the victim and perpetrator. D, if the relationship has terminated, the length of time since the termination. Definitions. Intentionally, intent, or intended means that a defendant's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent of or belief in the existence of conduct or circumstances constituting an offense. It does not mean that a defendant must have known that the conduct is forbidden by law. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. Recklessly or reckless disregard means that a defendant is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstance exists. The risk must be such that disregarding it is a gross deviation from what a reasonable person would do in the situation. A person who creates such a risk but is unaware of such risk solely by reason of voluntary intoxication also acts recklessly with respect to such risk. Physical injury means the impairment of physical condition. Serious physical injury includes physical injury which creates a reasonable risk of death or which causes serious and permanent disfigurement, serious impairment of health, or loss or protracted impairment of the function of any bodily organ or limb. Firearm means any loaded or unloaded handgun, pistol, revolver, rifle, shotgun, or other weapon that will expel, is designed to expel, or may readily be converted to expel a projectile by the action of an explosive. Firearm does not include a firearm in permanently inoperable condition. Physical force means force used upon or directed toward the body of another person and includes confinement, but does not include deadly physical force. Deadly physical force means either 1, force which is used with the purpose of causing death or serious physical injury, or 2, force which, in the manner of its use, is capable of creating a substantial risk of causing death or serious physical injury. Unlawful means contrary to law or, where the context so requires, not permitted by law. Endangerment. The crime of endangerment requires proof of the following. 1, the defendant disregarded a substantial risk that his or her conduct would cause physical injury, and 2, the defendant's conduct did in fact create a substantial risk of physical injury. Threatening or intimidating. The crime of threatening or intimidating requires proof that the defendant threatened or intimidated by word or conduct, 1, to cause physical injury to another person, or 2, to cause serious damage to the property of another person. Assault. The crime of assault requires the proof that the defendant, 1, intentionally, knowingly, or recklessly caused a physical injury to another person, or 2, intentionally put another person in reasonable apprehension of immediate physical injury, or 3, knowingly touched another person with the intent to injure, insult, or provoke that person. Aggravated assault. The crime of aggravated assault requires proof of the following. 1, the defendant committed an assault, and 2, the assault was aggravated when the defendant caused serious physical injury to another person. The crime of unlawful imprisonment requires proof that the defendant knowingly restrained another person. Restrain means to restrict a person's movements without consent, without legal authority, and in a manner that interferes substantially with such person's liberty by either moving such person from one place to another or by confining such person. Restraint is without consent if it is accomplished by physical force, intimidation, or deception. Sexual assault. The crime of sexual assault requires proof that the defendant, 1, intentionally or knowingly engaged in sexual intercourse or oral sexual contact with another person, and 2, engaged in the act without the consent of the other person, and 3, the defendant knew the act was without the consent of the other person. Oral sexual contact means oral contact with the penis, vulva, or anus. Sexual contact means any direct or indirect touching, fondling, or manipulating of any parts of the genitals, anus, or female breast by any part of the body or by any object or causing a person to engage in such contact. Sexual intercourse means penetration into the penis, vulva, or anus by any part of the body or by any object or masturbatory contact with the penis or vulva. Without consent includes any of the following. 1, the victim is coerced by the immediate use or threatened use of force against a person or property. 2, the victim is incapable of consent by reason of mental disorder, mental defect, drugs, alcohol, sleep, or any other similar impairment of cognition, and such condition is known or should have reasonably been known to the defendant. Mental defect means the victim is unable to comprehend the distinctively sexual nature of the conduct or is incapable of understanding or exercising the right to refuse to engage in the conduct with another. 3, the victim is intentionally deceived as to the nature of the act. 4, the victim is intentionally deceived to erroneously believe that the person is the victim's spouse. Any notes you may have taken during the trial are not evidence. The only evidence that you are to consider in determining the facts is the testimony of witnesses and exhibits admitted into evidence. Your notes are merely an aid to you for recalling trial testimony and the evidence. The law provides for a jury of 12 persons in a case such as this. As I stated at the beginning of this case, we have more than 12 jurors so that if a juror becomes ill or has a personal emergency, the trial can continue without that juror. In a short time, alternate jurors will be determined by lot in a drawing held in open court. The alternate jurors are still jurors on this case until they are released by court order. Therefore, alternate jurors will remain under the admonition and available to return if needed. I will read the closing instruction after the attorneys have completed their closing arguments. Mr. Martinez. Arguments. Mr. Martinez.
This individual, the defendant, Jodi Arias, killed Travis Alexander. And even after stabbing him over and over again, and even after slashing his throat from ear to ear, and then even after taking a gun and shooting him in the face, she will not let him rest in peace. But now, instead of a gun, instead of a knife, she uses lies. And she uses these lies in court when she testified to stage the scene for you, just like she staged the scene for the police after she killed Mr. Alexander. And this woman who would stage the scene has even attempted to stage the scene through the use of the media. She has courted the media. She has gone on national television. You've seen the programs and you've seen some of the her words to the media. She has also attempted or gone out in search of the limelight. She has signed a manifesto just in case she becomes famous. And to top it all off, she has indicated that she is innocent, that no jury will convict her, that none of you will convict her after she has staged the scene for you. Well, she is an individual, as you have seen, who has craved the limelight. So it seems that it is only fitting that this individual that has craved the limelight, it is really only fitting that she now bask in a different kind of light, the light of truth. And in the light of truth, you can see who she really is. She's an individual who is manipulative. This is an individual who wants to play the victim, even though there is no abuse, as you heard from those that know her. She's an individual that, according to her own statements in an email on Valentine's Day of 2007 to Mr. Alexander, said that she was destructive. She's the individual that talked about what she did to doors, what she did to windows. And she's an individual that does not appear to be very nice to her mother, because she lashes out at her and strikes her physically. Additionally, when the light of truth is shining on her, she is somebody who is just an individual that manipulates people. That, for example, when she's speaking to Mr. Alexander during that fateful May 10th, 2008 conversation that she talks about her sister, and says how dumb and stupid her sister is. This is an individual who is manipulative. This is an individual who will stop at nothing and will continue to be manipulative and will lie at every turn and at every occasion that she has. One of the examples is the issue of the gas cans. She indicated to you from the witness stand and looked at each and every one of you after having taken the oath and said, yeah, I bought the gas can all right, and I bought it from the Salinas Walmart. I did buy it from the Salinas Walmart, but you know, after being questioned by the prosecutor, you know, I took it back and I received cash. Yet, you heard from Amanda Webb, the individual or the woman who works for Walmart, checked each and every single register, even those that were not geared to give refunds, checked each and every single register. And each one of those registers indicated, no, there had been no such refund. And then, of course, you have the confirmatory action in Salt Lake City after first indicating that, no, I've never been in Salt Lake City. I've never put gas in Salt Lake City. But you saw the receipts that she had. And not only had she put gas into her car in Salt Lake City, she had two other transactions. One for 5.09 gallons of gas, and then one for slightly under 10 gallons of gas. She looked at each and every one of you, this person, and attempted to manipulate you. Well, this individual that attempted to manipulate you believes, based on what we've heard, that even though she may have engaged in actions, she may have done certain things, none of it, absolutely none of it, is her fault. Why could it possibly be her fault? If you look back in her history, which is the important part of it, involving her relationship with men, what do you see? Well, even when she was young, she had this personality of manipulating the facts. Back when she was with Bobby Juarez, what did she tell you? Well, this was an individual that was unfaithful to me. How could he be so unfaithful to me after I've done so many good things for him? I've tried to buy him clothing. I've bought him food. I even lived in a trailer that was so bad and it was infested. Never mind that the reason that I moved there was because I was skipping school. No, that wasn't my fault at all. No. I was doing this for Bobby. And how does he repay me even though it wasn't my fault? Well, you know what? He goes and he he sends letters to another woman over the internet. And it isn't her fault that she found out about it. Of course not. How could it be her fault that she found out about it if the library doesn't have enough security attached to that particular computer to have some sort of device attached to it so that somebody can't come along and just hit that backspace button so that whoever was using it before, maybe one or two or three or four people before that, somebody can just come along and hit that backspace button. It is eerily reminiscent of what she told you happened in February of 2007, where after she and Mr. Alexander began dating, that she went onto his computer and began to hit that same backspace button. It's not her fault that computers have not been improved since the 90s or the 2000s such that you can't stop hitting that backspace button. It's not her fault that that happened. Of course not. That's what she told you from the witness stand. And so, according to her, she hits the backspace button, and there it is, this conversation between Bobby Juarez and somebody else. But that's not her fault. But if you remember how aggressively she reacted to that, nobody was going to do anything to her, or nobody was going to be putting her or sliding her or putting her in a position of feeling inferior, if you will. She immediately went to Bobby Juarez and did something about it. There is a pattern because the same thing happened with regard to Matthew McCartney, the person that she jumped to after she and Bobby Juarez started to have problems. And I do say jumped to because when she was dating Bobby Juarez, he moved away to Oregon. And when he moved to Oregon, he started living with a guy by the name of Matthew McCartney. And when this thing soured with Bobby Juarez, she immediately went with Matthew McCartney. And in terms of that relationship, the reason that that broke up, it's not her fault. Just like it wasn't her fault with regard to Bobby Juarez, it wasn't her fault at all. that she had these issues with Matthew McCartney. No. She can't help it if she is a good worker. She can't help it if she's working as a waitress and people come by when she's working as a waitress and try to tell her things about her boyfriend, Matthew McCartney. She can't help that. That's what she wants you to believe. And again, isn't that reminiscent of what happened involving Mr. Alexander? It seems that this is cyclical, and it seems that the story repeats itself. And it repeats itself because she's lying. And it repeats itself because she's trying to manipulate you through all of the days that she spent talking to you from the witness stand after she had taken an oath. Well, she gets to the point where she moves to Palm Desert in California to be with an individual by the name of Daryl Brewer. And of course, when she's there with Daryl Brewer, it's not her fault, again, that relationship is souring. No, not at all. It's not her fault because, well, Mr. Brewer doesn't want to marry her. What's the girl to do? It's not her fault. She's got to look for another guy. And it appears that he doesn't want to have any kids, and she does. And so, again, it's not her fault. How could it possibly be her fault that somebody has free will? Absolutely not her fault. That's what she tried to tell you. But resourceful as ever, resourceful as she's always been, this person who is manipulative, she starts looking around for somebody else and decides that perhaps those boys from the Mormon faith are a pretty good catch because those boys, they have a lot of family values. And these boys, they work, they seem to be very successful, they just seem to have everything that she desires in a husband so that she can breed. And so, what she decides to do is to look for one of those boys. And to Travis Alexander's misfortune, he was that boy. And he was that boy back in September of 2006 when he was at this PPL convention, the yearly convention. Yes, he is the individual that went up to her, and they began to talk. And such is the way that things began between the two. Yes, he is the individual that went up to her, and they began to talk. And such is the way that things began between the two of them. She wanting to find a boy just like him because she had an ulterior motive. She wanted somebody that was Mormon. She wanted somebody that she could give her a child. And so this seemed like the perfect catch for her. And although she tells you that, well, he kind of was the person that pushed her in this relationship, and that he was the individual that somehow was this, that in the lexicon of the English language, there's a word. It's called no, that you can use when you don't want to do something. And yet you can then take the witness stand, however, and say, well, I do know that word, but just chose not to use it. But it's not her fault. Again, it's not her fault. It's Mr. Alexander's fault for being interested in her, don't you see? Can't you all see, based on those days and days that she was on that witness stand, that it isn't her fault? She was thinking no. Or at least that's what she told you. This person who told you also about the gas cans. Over and over again, she kept saying with regard to each and every single repetitious sexual act, with regard to each and every one of those, no. I was thinking no. Really, that's exactly what you were thinking. Did you ever communicate that to him? No. This from a woman who is manipulative. This from a woman who pretends to be the victim, even though there is no abuse. And so throughout this early part of the relationship, which some would call the honeymoon portion, during this part, it appears that they do what two people that are young and are involved in a relationship do. They engaged in relations. But there's this finger-pointing aspect to this relationship as portrayed by the defendant. Can't point the finger enough at Mr. Alexander. Can't point the finger enough at the fact that, he's a bad Mormon because he's having sex with me. If he's such a bad Mormon, then why stay with him? You're the one that chose him. If he's such a bad guy, why are you hanging out with him? And to compound things, well, she's also Mormon too. Why does she keep pointing the finger at him when she is just as Mormon as he is? She converted in November of 2006. And according to Deanna Reed, there are many classes that tell you about the law of chastity. And they tell you about the law involving sexual intercourse. But wait, it's not her fault. How could you possibly think it was her fault when those 3 or 2 Mormon missionaries that came over didn't tell her about it? Again, it's not her fault. Although there are all these classes where they talk about it, no. Let's point the finger at Travis Alexander because according to her, he's the bad guy. He's the one that told her that it was okay, and so she's going to go along with what he says, even though those in the Mormon church are telling her otherwise. It is almost unconscionable for her to point the finger at Mr. Alexander when she's in the same situation as he is. She has the same knowledge that he does. But again, she wants you to feel sympathy. Because again, it's not her fault. Don't you know? How could it possibly be her fault when she was thinking no? Well, luckily for Mr. Alexander, I guess, in the beginning, this relationship was from a distance. And I say luckily because at least when she was in Palm Desert, and he was in Mesa, Arizona during that time, at least during that time, she couldn't reach out and stab him. She couldn't reach out and shoot him in the face. She couldn't stalk him. Couldn't come over unannounced. She wasn't living the 10 minutes away. At least fortunately, during that time, Mr. Alexander had some extra time to live. And during that time, they were not mutually exclusive. So yes, it is appropriate when they are not mutually exclusive for an individual to send text messages to other women if they are male or even if they are not. There's nothing wrong with that. But if you see that long finger pointing from the witness stand to him, how could he possibly, when we were together, how could he possibly, before we became exclusive, be talking to other women? How could he be on the internet? How could he be sending text messages? But it's okay, don't you see, that when she goes to his memorial services, talking about Travis Alexander's memorial service, after she killed him, it's okay for her to talk to somebody on the airplane, to get a telephone number. It's not her fault that this guy was trying to pick her up. Of course it's not her fault. And what's a girl to do after all? The guy that she was involved with up and died after she stabbed him, slit his throat, and shot him. What is she to do? Can't you see that it really isn't her fault? At least that's what she wants you to believe. And during this period, Mr. Alexander did see her. And during this period, Mr. Alexander did engage in sexual contact with her. There's nothing, absolutely nothing important about that as it applies to the killing, other than to try to manipulate you, try to shock you and say, oh my gosh, look at this guy. He wants to kiss her and he wants to do other sexual things that other people do in their private lives. And he doesn't want to talk about it, for God's sake. That he doesn't want people to know what it is that they're doing. Why would he want anybody to know what he is doing sexually and with whom? Is that something that this is courteous in this society to do? It's just the opposite. But she has now turned the world sideways for you to look at that in an attempt to manipulate you. Well, they continue on with this relationship, and she lives out in Palm Desert. At some point in February of 2007, after this issue involving the February 14th mailing that she indicates that she receives, after that, they make the relationship, if you will, exclusive. What's interesting about the email from February 14th of 2007, and you saw that, is that not only does it talk about her violent tendencies, it does talk at length about that, but it also talks about other things. And you have it there for your review, this February 14th, 2007 email. And one of the things that it doesn't talk about is the package that she supposedly received in the mail that day. Take a look at the time. It's around 4:30, 5 o'clock in the afternoon. I guess they have mail that's really slow there in Palm Desert. never mentions these unholy underwear, these underwear, these Spider-Man underwears that so shocked her. Doesn't mention these chocolates. Thank you for sending those to me. Doesn't thank him at all. The reason she doesn't thank him, and the reason that she doesn't mention it, is because there was no such delivery. But of course, that's something that can't be verified, except that there's this inconsistency. And it starts showing that this individual will make things up. But she forgot. She forgot about that February 14, 2007 email. And you know, sort of the old saying, with the truth, you ain't got to remember nothing. At least you have to give her credit for having an incredible memory. Well, an incredible memory as to the fantasy world that she wants to create for you. Just like that delivery of the underwear. Can't show them to us. Why? Oh, she threw them away. But she took pictures of some other things. And this email was sent out at a time where she would have already received the mail. But after that, she and Mr. Alexander continue on. And she comes over later on in the month of February. And when she comes over in February, one of the things that happens is that she's extremely happy. Or at least that's what she tells you. And she's happy because one of the things that she now knows is that, well, she and Mr. Alexander are together. If she is so happy, if she is somebody that really wants to be accepting, then why, pray tell, does she need to go into his computer and hit that backspace button? That's such an irritation to her that these computers should have this backspace button. It's not her fault that she can't keep her hands off of this computer. It's really his fault. And it's really his fault because he's alive. He's a breathing human being who has social contact with other people, men and women. And how dare he, when they are not exclusive, how dare he attempt to spend New Year's Eve with somebody? He should really be alone in his house or in some hut somewhere alone. How dare he do that? But it's not her fault that she found that out. At least that's what she wants you to believe. Well, they continue this dating, and they continue both involved in this prepaid legal. But the story doesn't get any better. What we're able to glean or find out from the history of it is that it doesn't get any better. And one of the things that starts to happen, according to her, is that she starts feeling something. Of course, her feelings are so important. And rather than talk to Mr. Alexander about it, rather than say, oh, I have these issues, I'm a little concerned, what does she do? Well, they're on vacation. And when they're on vacation, and it depends on the story that she tells, the one to Ryan Burns or the story that she told you from the witness stand, take your pick, because there are many to pick from. But it depends on the story that you believe. During that time, she goes on and she gets a hold of his text messages and goes through all of them, ostensibly while he's either asleep or taking a shower. Take your pick. And while he's doing that, she goes through it and finds some text messages. But it's not her fault. She's not wrong in invading his privacy at all. How can she possibly be wrong about invading his privacy when she had feelings? And those feelings confirm the fact that he was a social human being. That's what in part that she liked about him, that he was very charismatic, that he was very nice, and that people liked him. That's part of the reason why she liked him, but oh no, not when it comes to other people. And she talked about him having sexual rendezvous with these other people. But that's quick, if you will, on the slime, and very slow on the facts, very low on the facts. You don't have any individual that they could even point to a name.
Objection, Your Honor, burden shifting.
Overruled.
There was no name that it was even pointed out that he even had any sexual contact with at that time. But she felt it, so according to her, that justified it. This person with this borderline personality disorder. And so as a result of that, she says, that's it. We're going to break up. And we're done with this. Except that I'm so hurt. I'm so absolutely hurt, she says. You could almost feel it oozing through those fake tears that were supposedly coming from her, from the witness stand. You could almost feel this. And what you could feel, of course, was, yeah, I'm really hurt, except let's go on vacation. Let's go ahead and go on vacation anyway. Even though I know all about this, I'm so hurt that I would rather go on vacation with you and enjoy it. And let's continue going on vacation. Yeah, that's her way of manipulating him. That's a way of not letting go of something that she wants. She wants to curb his free will, and what he doesn't want to do that, well, she's got something else coming for him. She is not going to let him get away that easily. And so she starts engaging in this conduct. So what else does she do? She does what every person who has caught their boyfriend, according to her, being unfaithful, what does she do? She moves close to him. Moves from California to Arizona, specifically to Mesa, very close to him, after they have broken up in the end of June of 2007. That's what she does. Well, now this is when the stalking begins. Well, maybe it was a little bit before that when she's going into his telephone. Or maybe it was before that on the first day that they decided to make this official when she started to go into his computer. There it is. It is clear from this relationship that there was this stalking behavior from the very beginning. And so she moves here to Mesa. If they are not dating, if they are haven't broken up, why is she here? It's not her fault, don't you know? It's not her fault because he's so persuasive. He talked her into coming out here. That's why she came out to Mesa. And it's this thing that she just can't say no. Just like with whether or not they're going to engage in this sexual conduct. Can't say no. And in this particular case, according to her, and Mr. Alexander's not here to maybe dispute this, according to her, she moved here because he was the one that told her to do that. Even though, according to her, at this point, she had broken up with him. And what does she do when she comes out here? Well, rather than dating, rather than becoming involved in some sort of social scene in the Mormon church or finding friends and that sort of thing, no. Does something else. She begins to be more attentive. That's the word. She begins to be more attentive to Mr. Alexander. Perhaps if she's more attentive to Mr. Alexander, perhaps then he'll want to come back and have her be the only one. And the way that she's attentive is the way that everybody does it normally. I mean, she goes over to his house unannounced at night, sometime around in August of 2007, and this is what everybody does. And she goes over there and starts peeping in a window to see what it is that he is doing. And he goes over there, and by the light of the television, if you remember there was this go-around, by the light. Well, it may have been the light of a television, but now it's the light of truth that we are looking at things. And what she was doing is she was invading his privacy by coming over and peeping in the window. And that is stalking behavior, irrespective of what Alice Laviolette has to say. This individual, Alice Laviolette, who had problems with the truth when she spoke to you about how many times she had testified on behalf of men. This individual who, quite frankly, misrepresented that to you when she was testifying. But according to Alice Laviolette, that was no big deal, because that's what a person does. She came over and started to look inside, and lo and behold, it's not her fault that she has vision. So she starts looking in there, and lo and behold, there he is. Yes, there he is, and he's kissing another woman. Like that is the end of the world. So what? So what that he's kissing another woman? He's not seeing her. He's entitled to do it. And he's entitled to do it. He's in his house. He has the lights off. It's a romantic evening. Whether she likes it or not, he's moved on. And yes, she says it's his fault. He shouldn't have been courting me. He shouldn't have been continuing to have sex with me. She could have said no. She could have left. She could have moved back to California. She could have never come out here in the first place. She's the person who starts to stalk him. And so she says, oh, I was so upset. And she starts talking about the brassiere, whether it was unhooked or not. And we went around and around about that. So what? Well, don't you know he's a Mormon boy? They're not allowed to do that. What does she care? Is she the Mormon conscience? Is that what we have going on here? No, she's not anything like that. But she wants to make it seem like it's his fault. She presented it in a way to manipulate your perception because he's trying to take away from him with lies the only thing that he has left, and that's his reputation. He's not here to talk about it, and so it's an easy shot for her. But at this particular point, she's the person that starts to stalk him. And after she starts stalking him, or after this event of stalking, she doesn't leave it alone. No, she comes over the next day because she's in the right. They've broken up, and it's okay if you're broken up to come over and peep at your ex-boyfriend's house, and then in peeping, find him doing something, and then wanting to get an explanation. What possible explanation could he ever have owed her at that point? Oh, and, she didn't write about, that's the first incident of domestic violence. Didn't write about that incident of domestic violence, don't you know? Because, well, she's a nice person. And there's this secret that she's watched, this movie involving The Secret, that talks about the law of attraction. And this law of attraction says that you lie. That's exactly what they want you to believe. Now they're starting to justify the lies. It's okay to lie in the journal, which in a sense is saying lie to yourself, because the law of attraction says it's okay to lie. Absolutely okay to lie. You don't put down exactly what's going on, and so you don't write about this. Actually, what's going on here is that she's making it up, and there's no corroboration of any incident whatsoever. And so this relationship, if you will, if you want to call it that, continues. And there are more exploitive, sexual kinds of things that are presented. And that you are regaled with the most intimate details that you could possibly think of. And every time it was, well, I was uncomfortable. But I didn't want to tell him no. It was just uncomfortable. Wait a minute. But she also sent him text messages. And those text messages indicated that she was not uncomfortable. She's the one, and I don't need to repeat it, you remember those text messages, where she's the one that's requesting the sexual acts. She's the one that's saying to him, if you're good, this is what's going to happen, and then I'm going to want something else. So she's the individual that, if we look at the corroborative, the independent evidence that we have, she's the individual that's in this as much as he is. There's no indication that he was ever forcing her to do anything at all. But she's attempting to manipulate you by saying, well, yeah, I went along, but I really didn't want to. And with regard to these acts of physical violence, well, they weren't so bad, and I didn't write about them. And with regard to any particular physical act of violence, there's no one that knows about it. There's no one that has seen any bruises. There are no police calls to 911. And she has a reason for that. The reason that she didn't call 911 involving Mr. Alexander is because she had a similar experience with Bobby Juarez. And when she had that similar experience with Bobby Juarez, well, she called 911, and you know what? Those 911 people in California, you can't trust them because they talked to Bobby Juarez, and as a result of talking to Bobby Juarez, well, they didn't come out, and so I was so soured by that circumstance that I just never decided to call 911. She's trying to provide a justification as to why there are no 911 calls. The reason there are no 911 calls is because it never happened. Everything in this case points to the fact that it did not happen. There are no medical reports, there are no friends, there is no one that can come in and say anything about that. There are no medical records, there is absolutely nothing to the contrary. What is it that you have? Well, on the day that she, in March of 2008, when she told Mr. Alexander, according to her, that she was leaving, he turned around and he hit her. And according to Alice Laviolette, he slapped her, but the defendant went round and round and said, no, it was the back of the head, the side of the head. It depended apparently on her whim as to where he hit her. But if you take a look at the entry for that particular day in March of 2008, You know, I told him, he was so upset. And he didn't want me to leave because, you know, we were both so in love with each other, is what she writes. And then she says, oh, he kissed me so tenderly 3 times. They were such wonderful, tender kisses. Is that what she means when she is talking to you about domestic violence? Kissing. See, that's the problem. You didn't get it the first time. Kissing is domestic violence. Tender kissing is domestic violence. But then you bring an apologist like Alice Laviolette and you say, no, that's not what it means. You need to go behind this diary here. Those words don't mean what they say. You need, for example, a little cheat sheet that tells you that under the law of attraction. That's not what it means. Under the law of attraction, it means just the opposite. It means that he did hit her. Can't you read that? What is wrong with you, almost, is the way it's being put to you, that you can't see that you can't buy or can't be manipulated. And the other thing that we have is that she claims that on January 22nd of 2008, there was also this act of domestic violence. It matters not what the act was at this point, because there's no corroboration involving that act of domestic violence either. All we have is a journal entry of January 24th of 2008. And in that journal entry of January 24th of 2008, she writes, you know, as far as January 21st, 22nd, and 23rd, nothing noteworthy happened. Not only do we have the diary relating to that, it says nothing happened. But again, you are being asked to take a leap. You are being asked, such as in the gas can example, to think that everybody else is wrong and she's right. And in that example, the one involving the 24th and the supposed incident of domestic violence on the 22nd, you are being asked to say, no, something noteworthy did happen on the 22nd of January. And the thing that was noteworthy on January 22nd of 2008 was that he beat me. And this is the time that I had my hand up. And this is the time that he came after me. But it doesn't say that. Not only is there not any corroborated evidence that can be presented, it's to the contrary. She herself said that it didn't happen. But she wants you to go back and say, well, don't look at what I wrote. Look at this code, this law of attraction. Take a look at that. Combine that with my words. Combine it with what Alice Laviolette says. We'll add that in there. And once you do that, you will be able to see and you will be able to know that, hey, you know what? He did. He did abuse me. And right before she leaves in April of 2008, she says that another incident happened. But she doesn't tell anybody about it. She still stays at his home. And off she goes. And what's interesting about these acts of domestic violence is that she was very specific as to 4 of them. But again, you know, with the truth, it's very hard to keep it straight. With the truth, you ain't got to remember nothing. But if you're not telling the truth, if you're trying or attempting to manipulate, you do have a lot to remember. She forgot that there is a psychologist by the name of Cheryl Karp that has previously been involved in this case and had conducted an evaluation of the defendant. And during that evaluation with the defendant, she gave many, not 4, many, 10, 15, 20 incidents of physical violence. Because at that point, physical violence was being used as the predicate, if you will, the seminal act for post-traumatic stress disorder. That's what she was looking at that time. And so, of course, let's have a lot of acts of domestic violence.
Arguing facts, not in evidence.
Overruled. The jury is directed to recall the evidence presented during the trial. You may continue.
And so you now have this lots of acts of domestic violence that she doesn't tell you from the witness stand compared to 4 that she does tell you. Which one is true? The only evidence that you have indicates that none of it is true because she can't keep it straight. And she's attempting to manipulate the evidence to fit the goal that she has at that particular time. With regard to Cheryl Karp at that time, according to Janine DeMarte, one of the things that was going on is that Cheryl Karp found that post-traumatic stress disorder of the defendant involved these acts of domestic violence, these many, many, many acts of domestic violence, not just 4. And so now when they want to talk about this in a different vein or a little bit differently, it's not just all these acts, it's only 4. And that's the problem with the presentation and her attempt to manipulate you. It's actually not even an attempt to manipulate you. They're lies. That's what they are. And she forgot, perhaps, about speaking to other people and the statements that she made with regard to that. Well, she does move away. And when she does move away, it's almost, if we're talking about light, almost like a ray of sunshine for Mr. Alexander. One can only imagine that his stalker is now far away, because she had done other things while she was here. One of the things that we know is that she would come over unannounced. One of the other things that she would do is she would get into his accounts. And there's also this incident involving Christmas and being underneath the Christmas tree. There's all these incidents. Perhaps Mr. Alexander can let his guard down at this particular point, because he really doesn't have to deal with her on a daily basis. And yes, there is some contact between them on May 10th of 2008. And this is the infamous phone call that involved sex. And actually, that telephone call is very important because you can actually hear how she deals with him. Even though he doesn't know, based on everything that's in the recording, that he's being recorded. She says, no, it was being recorded pursuant to his request, don't you know? Really? Why was it being recorded at his request? He's not going to be, can't listen to it. So what possible benefit is this call going to be for him? If he's recorded, if he's not going to get it. There's absolutely no benefit to him on May 10th of 2008 to have that telephone call recorded. Yes, he said some things on it. But this is supposed to be, from his perspective, a private conversation, never to be released to anybody, between him and this woman that, even though she's moved to Wairika, even though they've broken up, even though she's come over and watched him with another woman, even though all of this has happened, she stalked him. Even though all of that has happened, well, he's going to continue talking to her on the telephone. And he says, and he tells you the reason why. And the reason why is that he enjoys having sexual contact with her. And he gives you the reasons why. And he talks about some specific features that he didn't do before and that he does now. He talks about how she introduced him to certain things, how that was such a good thing, kind of opened his horizons with regard to that particular aspect. And so he's giving her credit for opening his eyes sexually. And there's nothing wrong with that, and there's nothing wrong with the conversation. What is wrong, or what appears to be wrong, is that one of them is recording it without the knowledge of the other.
Objection, facts not in evidence.
Sustained.
You'll be able to listen. You've listened to that recording. You can draw your own conclusions as to whether or not you believe he knew or believed that this is something that was being recorded. She says, no, I kept hitting the save button. I was the one that did it. And she kept it. And she kept it all the way from May 10th of 2008. But things were not going so well at that point. And in fact, by May 19th of 2008, just 9 days after that, Mr. Alexander is on the computer, this instant messaging service, with somebody named Reagan Housley. And he's talking to her, and he says, I'm extremely afraid of Miss Arias because of her stalking behavior. How prophetic of him, back on May 19th. And this is 9 days after this telephone call. But he's extremely afraid of her because of this stalking behavior. Little does he know that he has less than a month to live. And so he is aware of it. He knows that he's in the best position to know what is going on between the two of them because he's the one that's going through it. And so when he makes that comment is indicative of what is going on. You can have people like Alice Laviolette say, it's not true. And the reason, and we have to give her credit, is that the reason Alice Laviolette knows that is that she can read minds through the past. She can travel back to May 19th of 2008 and know what Mr. Alexander was thinking, don't you know? She's the apologist or the defendant. She's the one that can really set you straight. It's not the defendant that's manipulating you. No, no, no. If you take a look at that statement, Mr. Alexander was making it all up. Wasn't true. He was just saying it. Because, you know, in another part of the instant messaging, they were saying, aha, hi, Jodi, read this, or words, whatever it is that they were saying. And so, the defendant doesn't want you to pay any attention to that. But that certainly goes, and it's the beginnings of premeditation. Her premeditation to kill him back on May 19th of 2008. He indicates that. I am extremely afraid of the defendant because of her stalking behavior. And who would know better than him? Especially since he's the one that's had to deal with her coming over, peeping in his window. He's the one that's had to deal with her showing up unannounced. He's the one that's had problems or damage to his car, according to Lisa Andrews. And he's the one that has her underneath the Christmas tree and has had a ring stolen by her. So he would know that. And so then, what ends up happening is that some time passes. And May 26th shows up. One of the important things about May 26th is that that is the day that they break up. And there's much is made by the defense that, well, during these conversations, he's mean to her. Well, why wouldn't he be mean to her? Yes, there are names that people are being called. That's correct. There are not any nice names. But he is extremely afraid of her stalking behavior on May 26th when those names are called. And there is anger that is being exchanged back and forth, and he sort of capsulizes it by saying, or using a term that's not quite so sexual, but really capsulizes what's going on here and how the defendant attempts to manipulate the truth. When he says, I am nothing more than a dildo with a heartbeat to you. That's what he tells her, because that's how he feels. That's how she makes him feel. And yes, he uses all of those other words, but he's also very derogatory about himself. He knows what's going on. Every time that, according to that statement, whenever she wants him, the way that she manipulates him is through sex. That's made that comment. So, and that comment was on the 26th of May in that instant message. But you don't ignore what else is going on the 26th of May of 2008. On that prophetic day, he also tells her something else in Exhibit 450. She's apologizing to him. Again, she's manipulating him. She does something and she apologizes and everything is supposed to be okay. But by this time, he has had enough. And he says, I don't want your apology. I want you to understand what I think of you. That's what he's telling her. He's telling her he wants her to understand what it is that he thinks of her. He says, I want you to understand how evil I think you are. At that point, when he's writing that, he is extremely afraid of her because of her stalking behavior. And he does think she's evil. And how prophetic. Look at it, these next words, how absolutely prophetic. No one can dispute that that is the truest, those are the truest words that are spoken in this case. And they're spoken by Mr. Alexander, even though he is not here, through his writings. You, Jodi Arias, are the worst thing that ever happened to me. Any doubt that that's the truth? Do we need to look at the pictures of his gashed throat? Do we need to look at the sort of frog-like state that she left him in, all crumbled up in that shower? Or do we need to look at his face where she put that bullet in his right temple to know that what he says there is true? You are the worst thing that ever happened to me. He's telling her enough is enough. And yes, he's angry. Absolutely angry after everything that she has done to him. And you've seen the manipulation as she has tried to manipulate you with what she has told you. And the prime example is these gas cans. No one can argue that she lied to you. Well, he's had enough. And yes, he says, you are the worst thing that ever happened to me. And then he says, in this Exhibit 450, you are a sociopath. No, he does not have a psychology degree. But that certainly expresses a feeling about what she says, what she does, and how she deals with him. How she always is manipulating him. It teases this anger out of him and tries to mix in the sex. And he says, you only cry for yourself. Well, you saw her crying on the witness stand. Can anybody debate the reason she was crying? It's because she cries for herself. After all, she never intended to be caught. She said that so herself after she lied to the police. Oh no, I was saying it because I did not want to be caught. And so, you only cry for yourself. And then he says, you have never cared out me. Supposedly that could be 4. And you have betrayed me worse than any example I could conjure. She has betrayed him. For whatever reason, he believes that she has done something that is absolutely horrific. And he's telling her, I've had it. I'm done with you. And again, this is May 26th. He's done with her. You are sick, and you have scammed me. Again, she has scammed him. Are you going to allow her to scam you? Is really the question from this text message. Are you going to buy her lies? Are you going to believe what she tells you? And so, we get to May 28th, just 2 days afterwards. Just 2 short days afterwards, he begins to plan, if you will, this killing. And planning takes preparation. And there's no doubt that this woman is a very intelligent woman. And she tries to cover all of her bases. And yes, she could go out and buy a gun. But you know, if you buy a gun, one of the things that she indicated in California was that there was a waiting period and they take your name. According to her, that's something that she knows. Well, let's get a stolen gun. She lives with her grandparents in Wairika, and she knows that that her grandfather has guns, and she knows where he keeps them. So on May 28th of 2008, she starts the planning. She starts the actual steps, or begins the actual steps to this journey that will take her to Mesa, Arizona to kill Travis Alexander. There is no other explanation than that she's the one that stole that 25 caliber gun. This very small gun that, according to her, looks like a toy. This small gun. And on May 28th, at a time when she's living there, there's a burglary that is reported at her grandparents' house. And lo and behold, it's so amazing. And again, this is the manipulative aspect of this case and the defendant. It is so interesting that this burglary of the house is kind of weird. It's kind of strange. It's kind of special. Because these burglars were meticulous. They wanted to leave the impression that this was a burglary throughout the house. So they went through 4 rooms. And from each of the rooms, only one item was taken. And where the guns were, you saw there was some money there. These burglars didn't want money. They just wanted the gun. And they didn't want any kind of gun. They wanted a special gun, a small gun, because there were rifles there. If a burglar comes in, he's not going to be very discriminating. I'm going to take this little gun I don't want to take the money, maybe too heavy. These other guns are too big. I'm not going to be able to carry them down the street. That's not the way a burglary happens. And oh, after I've taken one item from here, I'm going to go ahead and go to another room. And after looking in this other room, I'm going to take one item from there. And then I'll take a total of 4 items. If you're going to do that, if you are a burglar, then why? Why even waste the time of committing a burglary? The only thing that makes sense with regard to the burglary is that the burglar, the person who went in there, is right there. It's Jodi Arias. That's the burglar. And she needs a gun. And she needs a gun to kill Travis Alexander. And she gets it. Guess what? Can't be traced. There's this burglary report out there. No one can say it's her. Well, at least not initially. No one can say it's her. But on May 28th, she begins to take these steps after he has told her in that May 26, 2008 text message that he'd had enough of her. And so what does she do as part of that? Well, she then says, but if I go to Arizona, money is tight, there's an issue with money. One of the things I'm probably going to have to use is my credit card if I go to Arizona, if I fill up with gas. So I've got to make sure that people don't know, if I'm going to carry this out, that I'm going to be in Arizona. Because I can't be linked to Arizona in any way, shape, or form. And certainly using a credit card at a gas station is going to link me to Arizona. And so, well, why didn't I call Darryl Brewer? You could tell from the time that he testified that he still had feelings for her. In fact, when he was asked about this issue, about the gas can, he actually paused, if you remember, and he gulped and he said, oh yeah, she did call me. She called me at the end of May. May 28th is the end of May when this gun is stolen by the defendant from her grandparents' home. Yeah, she did call me then, and she told me she was going to Mesa. She was going to Arizona. And Alice Laviolette has the same thing in her notes, that according to Darryl Brewer, the defendant called him at the end of May that she was going to Mesa, Arizona, and needed gas cans. And Alice Laviolette, even in her notes, indicated, I thought that this was an unplanned visit. Even in her notes, there are issues. But the defendant's attempting to manipulate the truth. But there are issues with regard to this, because she's telling Darryl Brewer that she's going there. Even her own expert says, there's a little bit of an issue here. There's a problem for me, because I thought you said that you were not going to Mesa, that you were going to Utah. Or is Utah just not anything else other than more than a ruse? You can say you're going to Utah. You can have a sexual dalliance, not an extreme one, but a sexual dalliance with Ryan Burns. You can adjust him, and nobody will be the wiser. Because nobody will ever know that you were in Arizona, because guess what? You never filled up anywhere. You never put gas in the car. Well, okay, that's what she does. She calls Darryl Brewer the end of May, the first part of June, and she gets these 2 containers, 2 5-gallon cans for gasoline, and they were empty. So it wasn't like they were full. And he lives in the Monterey area, and she leaves on June 2nd. Well, when she leaves, she doesn't take her own car. She decides to rent a car. And she has told you, well, I rented the car out of Redding, California. And the reason that I rented the car out of Redding, California, which is approximately 90 miles south of Wairika, is because Priceline did not offer this same deal in Wairika. Priceline only offered it in Redding. And that's why I went ahead and did it that way. It wasn't that I didn't want people in Wairika to know what kind of car I was renting, because heaven forbid, if they knew I was renting this car, it could come back to me. And of course, I don't want to be identified in killing Mr. Alexander, so I've already made provisions for the gas cans. Now I've got to make provisions for the car. And so she says that's the reason why she goes to Redding, California. Except that the documents show something else. Exhibit 523 is the statement from Washington Mutual from June 1 of 2008 to June 30 of 2008. And this is the statement that she, the defendant, authenticated on the witness stand. And in fact, what we have here is the budget rent-a-car. You see it, June 9th, budget rent-a-car in Redding, California. That's what we're talking about. But if you also remember, after she killed Mr. Alexander, she came to the memorial, and she flew down here. And if you take a look at down here, there it is. See that? She paid $246.99, and that was to Priceline.com, and it says air. This Priceline, they have to get their act together here. Yeah. At one point, when it comes down to the flight, I pay them, but when it comes to the car, even though I go through Priceline, I got to pay for the car. And how is Priceline ever going to get paid if they don't take their money up front for the rental car? That's how it works. They get their money up front.
Argue, objection, arguing, objection, non-hearing.
Overruled.
They get their money up front. And that's how it's listed in these documents, so that we know who's getting the money. Otherwise, if it were left to budget, then you're imposing upon budget, if Priceline is involved, another accounting step to then pay Priceline. And it may be a situation where Priceline never pays them. So by this document right here, when the defendant tells you that the reason I went to Redding was because of the Priceline connection, she lied to you. Unless, of course, Washington Mutual made this up. Maybe Washington Mutual also subscribes to the law of attraction, and they don't want to put anything negative here. Maybe. It could happen that way, right? That's what they want you to believe. Don't believe what's written down. Believe what I say. That's the same situation here as it is with those diaries. They want you to believe not what the diary said, what she tells you. They don't want you to believe what that document says. They want you to believe what she says. So now, we know that she goes to Redding after she's made provisions for the gas cans. She goes to Redding so that people will not recognize her because she is going to kill Travis Alexander. There is no other explanation for making up all these stories that we're talking about here. There is no other explanation. Contacts Daryl Brewer, now has the gas cans, now has the car rented, and still, this car, it's in Redding, where people are not going to know her. And in fact, it's at an airport. By definition, an airport is where people come in and they leave, they're traveling. Those are not the kind of people that you're going to run across at the supermarket. And so it's a way for her to hide. And she shows up there, and Mr. Colombo says to her, got this nice little red ditty over here for you. Nice little red car that you could drive on your way to Arizona, or not Arizona. Just drive around. And by the way, where are you going to drive? Oh, just around town. That's all I'm going to do. Why did she lie to him? Why did she make that up to him? Because she didn't want to tell him that she was going to Mesa, Arizona, like she had already told Daryl Brewer. Because then again, that would connect her. But why not take the red car? Well, according to her, red cars call the attention of the police. And she certainly doesn't want that. She doesn't want the police to find out about her because she's on a mission. She's on a mission to kill somebody. Why would you take a gun if you are going to go on this trip other than to kill this guy? And she says, I didn't know that I was going to go there. Even though I told Daryl Brewer, I didn't know I was going to go there. Keep in mind that this is a rental car. And one of the things that she says as she's pointing the finger at Mr. Alexander and how viciously sexual he is, do you remember when she claimed that she was down in that office? Do you remember she said, we were down in that office and I had brought over some CDs from the trips that we had taken with some photographs. You remember that? And she said, I had scratched him. For whatever reason, she had scratched those CDs. And he got mad and threw that CD. Because, you know, that guy, he gets mad at everything. And so I then have to have intercourse with him to calm him down. That's what she said. If she's not going to visit him, if she's not going, thinking, or if she hasn't already made up her mind to leave Wairika and visit Mr. Alexander in Mesa, Arizona, why? Why take these CDs of the trip with her? Why take these CDs? Who is she going to show these CDs to other than him? And she's in a rental car. So that requires a volitional movement on her part to take something from inside the house or her car, whichever one she does. But it requires a volitional movement to get those CDs into her car and drive down to Redding, California, and then put them in the rental car. There is no other explanation for those CDs to be in Mesa, Arizona, other than that she knew, she absolutely knew, and had already planned it. She knew she was going to kill him. Why else take the CDs? Do you think that Joe Colombo wanted to look at them? Do you think that her family in Redding cared? The ones that she claims took her to the airport. Nobody cares about that. But it's a good way to disarm, if you will. Or it's a good excuse to show up unannounced somewhere. Look, you know, the only reason I'm dropping by, just like I did back in August of 2007, the only reason I dropped by was to show you this. It's not my fault that you haven't seen these, and it's not my fault that I haven't been able to get them to you. Not my fault at all. Not at all. But you know, I'm making it up to you now. She left Wairika, California with those CDs. But she forgot about it as she attempted to manipulate the story from the witness stand. She forgot about it. It's those little details that she forgets. And so she brings those CDs and doesn't want the red car. And the reason she doesn't want the red car because, well, police will see her. Doesn't want to be stopped by police. And it's actually foretelling of what happens later. Because she's stopped in West Jordan, Utah by the police. For a different reason, but she is stopped by the police. And she's right. According to her mind, a red car is more significant or stopped more prominently or frequently by police. Doesn't want to be stopped. Because what if she's stopped in a place that shows that she's going to Mesa? She wants to hide the fact that she's going to Mesa, Arizona. And the only reason to hide that fact is because she's going to kill him. It isn't like the bishop is going to be upset if she shows up in Mesa, Arizona. It's not like her family's going to be upset if she shows up in Mesa, Arizona. She's an adult. It's not like her friends, whoever they may be, because we don't know who they are. They're not going to be upset if she shows up in Mesa, Arizona. The only reason to keep this whole thing a secret, which is what she tried to do, is because she was going to kill them. And she's making preparations. And she's very good at making these preparations. You do have to tip your hat to her. First of all, the burglary. She does a burglary. There are no suspects. One of the only things to take it is this .25 caliber. It's lost. It's out there. It's .25 caliber handgun. Then she rents this car and then takes the white car. And the white car does have some floor mats in it. She takes this white car and says, I'm only going to drive around here. Again, she lies. Makes that up. It's like a field of lies that has sprouted around her as she sat on that witness stand. It's every time she spat something out, another lie, another weed would grow around her. And so she gets in that car, heads out, and sleeps the night at Matthew McCartney's house. And the next morning, June 3rd of 2008, she then shows up over in Monterey, the Monterey area, shows up there in the morning and sees Daryl Brewer. And yes, she now has 2 gas cans. And the only reason to get these gas cans is to put gas on them. There's no other reason why anybody would get a gas can to go on this trip. Well, the ostensible reason to get these gas cans is perhaps gas is cheaper in Utah, or maybe gas is cheaper in Nevada than it is in California. And that's one of the reasons that's given. But if gas is cheaper in Nevada or Utah, and she does fill them up in Utah, why then? Why would she fill them up in Pasadena? Why would she fill up these 3 gas cans in Pasadena? The only reason she would fill these gas cans up in Pasadena is because she was going to take the drive to Mesa. And sure enough, there is no evidence that she ever was in this area through this gas, by purchasing gasoline. Everybody that travels in, if they stop somewhere and use a credit card, it's easy to trace. But not if you don't stop anywhere. And so she picks up these 2 gas cans and begins the drive. And after she begins this drive, now take a little detour. And this little detour is after some thought, because this is a meticulous approach to premeditation. This is a meticulous approach to killing. Again, why stop in Salinas, California at a Walmart to buy another 5-gallon can? Because she's been thinking, and she thinks, 10 gallon, let's say that maybe 30 miles per gallon, that's only 300 miles, so I need another 5, maybe that gives me another 150 miles. That's 450 miles. That gets me through Arizona and into Nevada. So she stops at the Walmart. And she stops at the Walmart and she does buy a gas can. She admits it. So when you look at this receipt, 237.008, and you look at it, the bottom item there for $12.96 is the gas can. I guess that's the price of premeditation these days. $12.96. And she admitted, yeah, sure did. On cross-examination, I bought that gas can. But, and she was very specific, I took it back to this same store, 2458, on that same day.
Objection, facts not in evidence.
Overruled.
You remember what she said on cross-examination when she was asked, where did you take that gas can back? And on cross-examination specifically, she said, I took it back to the same store that I bought it from.
Objection, mischaracterizes testimony.
Overruled. The jury is directed to recall the evidence.
And do you remember at that time that the question that was followed up was, well, would it surprise you that that store in Salinas doesn't have any record of that? And her answer was, yes, it would surprise me because I got money back. I got a refund. That's the way the exchange went. And your notes should reflect that. So, didn't take it back there, did she? But she told you that. Why did she say that? Why did she tell you that? Because that's just crushing, if you will, in terms of whether or not this is premeditated. And it is premeditated. She was coming to Mesa with a gun and a knife. This knife appeared from somewhere, so she had to have brought it up. Knives are not in a bathroom. So she stops there after thinking about it and now has another gas can, which gives her a further range. If we use 30 miles per gallon, we're talking about an extra 450 miles. Well, one of the other things that she does as part of this premeditation or part of what's going on is that, if you want to do something like this, it's a good idea that when you show up, that people not recognize you at the place where you're going to commit this murder. And so if you have blonde hair and you saw the photograph of her with the blonde locks and the black dog and how they told you that that's the same color. Do you remember that line of questioning that went on with Lonnie Dworkin, their expert on computers? The question was asked, well, do you think that this hair here with the dog looks the same as the one where she's laying back? Do you remember that line? Like he was some sort of expert on hair color. You don't need anybody to tell you what the hair color was when she was there with the dog. You can see for yourself. You don't need the prosecutor or anybody to tell you. But you do know one thing. You were also shown photographs that were also taken on June 3rd of 2008, about this same time, and you saw the hair color, didn't you? Are you going to believe Mr. Dworkin and the defendant, or are you going to believe your eyes? Maybe the law of attraction tells you that you should believe Mr. Dworkin. Because again, you can't believe the text messages. You can't believe what's written down on the receipt, and you can't believe what's in her journal because of this law of attraction. Now you can't even believe your own eyes. Because if you do believe your own eyes, you know she's premeditating the murder. She's thinking about killing him. That's all that's required. The state doesn't even need to prove a whole plan such as this. All the state needs to prove is that the defendant thought about it, the killing, before she actually carried it out. And this is an extensive amount of planning. Days, 6 days in advance, 6 to 7 days in advance of her killing him, a week or so. And so she stops there, makes more preparations. Now she can freely drive through Mesa with enough gas so that she doesn't have to stop anywhere. More thinking that goes on. And she tells you, well, I hadn't planned on going there to Arizona. Hadn't even thought about it. But Mr. Alexander, that guy, always guilting me. This is, God, it's just like a bad disease, this guy. Always guilting me. It's not my fault. That's what she's telling me. And it ain't my fault. I told him I was going to go to Utah, and he was a little bit suspicious about why I was going to Utah, but why don't you stop here in Arizona? You can stop here in Arizona. That's what she told you that he said, or that he implied, that he wanted. She kept saying, no, you're going to come up here to see me after your trip in Cancun. It's okay. Well, the problem is that it's her word. Do we really know, based on all these lies, that that's what he told her? Or was there just a call to try to find out what he was doing? Does he have a visitor there? Does he have somebody there? What are his roommates doing? Are they going to be there when I arrive? What is the situation there? Are you going to take her word for that? Is there any indication anywhere that Mr. Alexander even knew that she was coming down there? You have her word. In cases that are minor to you, not even important cases, are you going to take her word? And remember, this individual has no problem with telling lies. You've seen throughout this whole trial. Well, she says that she does have this conversation with him. And in fact, the bone records do bear out that there is a conversation. But the content of the conversation is still in doubt. And I only have to point out to the point as far as the May 10th, 2008 conversation in terms of showing that she has no problems lying on the telephone where she says, well, yeah, I was faking it. And you know what she said she was faking. Even though you heard her squealing like a cat. No, that's just me faking it. And you know why? Because I need two hands. That's why she was faking it. Okay, well, if you can lie on May 10th of 2008 on the telephone to Mr. Alexander, what makes us think that you can't lie about what you and he talked about on June 3rd of 2008? And remember, she's got this history all along, not only of lying outside of the courtroom, but she has sat on the witness stand, a place where you have taken an oath, a place that is sacrosanct in finding the truth, has sat on that witness stand, looked at each and every one of you in the eye, and lied to you, specifically the gas cans, specifically about Priceline. And to another extent, the finger. If you remember, she said, he was starting to kick me, he broke my finger. I didn't get any medical care, but he broke my finger. Or, alternatively, I actually was working at Casa Ramos before I went. And when I was at Casa Ramos, or Margaritaville, one of the two, you take your pick, because that's what you told Mr. Burns. And either I went up against one of the edges, the metal edges, and it cut me, or, alternatively, it was a margarita glass. No, and then she takes the witness stand and says, well, in terms of the damage to the finger, I actually damaged the finger when I was at Mr. Alexander's home on June 4th of 2008, but the glass was that. That's how it happened. What story are you going to believe from this individual? And that's the issue here as to when she tells you something, what are you going to believe? And so She leaves that area, and off she goes. Drives to Pasadena. We know that telephone calls with Mr. Alexander are after that, but she drives to Pasadena. And then something that is so bizarre happens to her. It seems that there's this coincidental horde of skateboarders in Pasadena. That's the way the kids are there in Pasadena. They go in hordes, these skateboarders. And this horde of skateboarders, well, they carry screwdrivers. That's one of the things. If you're going to be in this horde of skateboarders, you have to have a screwdriver. That's what you got to do. Or else you're not allowed in this particular club out in Pasadena. And you can get a strawberry frappuccino or whatever it is that you get at Starbucks when you go there. Be careful, because when you go in to get this strawberry frappuccino, things are going to happen to your license plate if you run across this horde of skateboarders with this screwdriver. And so when she was questioned about that in cross-examination, one of the things that she said was, well, yeah, I was pulling out after stopping there. And I was pulling out and I saw something flat on the ground. And when challenged on that, if you see something flat on the ground, what makes you think that you can go and pick it up? What in God's name would ever motivate you to go and pick this up? Especially if you were afraid of this horde of skateboarders in Pasadena. Because she did say that she was concerned for her safety. Why even get out of the car if you don't even know what it is, and if you don't even know that it's related to the car? And she said, I didn't know it was related to car. I didn't know what it was. And she's having problems with the truth there because, remember, she remembers that she's got the license plate in the back that she's got to deal with, this issue involving the license plate in the back and whether or not they're connected. And she says, oh, I don't even know what the license plate was. I didn't even look in the back. When challenged further, she said, oh, wait a minute. No. It wasn't flat. It was actually standing up. And it was standing up, and I was able to reflect and realize that it was these, not square, she corrected the prosecutor, rectangular. Remember that? It was rectangular object that she recognized as a license plate. And if you don't have any suspicion whatsoever that it has anything to do with your car, why then? Why would you even get out of the car and go look when you're scared to get a license plate? Why on God's green earth would you do that? When you're lying, that's when you would do that. That's exactly when you would do that. But she says, oh, I went and got it, and I really couldn't tell the numbers, and I didn't compare it to the back. So now you're a thief. Somebody else's license plate is sitting out there. You don't know it's yours. Potentially, if it's not yours, it's somebody else's. They may potentially come back for it. So what are you doing? You're stealing it. You're depriving them of the opportunity to have the front license plate, which is obviously required in the state of California because this car had two of them. So that's what you're doing there, because she didn't check to see if it corresponded with the one in the back. And the reason that she's having problems with that is because, as you know, in West Jordan, Utah, the one in the back is upside down. Like somebody took it off. And like somebody put it in the back seat of the car when they arrived at Travis Alexander's house, so that the car wouldn't be able to be identified to them. Just like that. That's, but you can't admit that, and that's why she's having problems with this license plate that's out there in this parking lot. And she ends that conversation with the prosecutor during cross-examination by saying, oh, well, I didn't see numbers or whatever, because you know what? I can't see. I needed glasses back then. So I really couldn't see. So I just grabbed it, and it had bugs on it, and so I thought it was mine. So without any regard to whether or not it really is hers, throws it in the back seat of the car. Who does that? No one does that. Making it up. And she's making it up because she got stopped in West Jordan, Utah, and has to explain how it is that the front license plate got into the car. Because this horde of skateboarders from Pasadena, they can't get into her car. So she has to be the one to do it. And the only way that she can say that she's the one to do it is to make up a story. And she made up the story about these skateboarders. guess it's this wild board kind of thing where you have to have the screwdriver. They're the ones that did it. And you know she's making that up. She's lying to you about it. And the reason she's lying to you is because in West Jordan, Utah, that license plate was found in her car. So one of the other things that she doesn't... Okay. We decide.
Recess. Please be back in the designated area at 1:30. We will start promptly at that time. Please remember the admonition, you are excused for lunch.
Please stand for the jury.
The record will show the jury has left the courtroom. We are at recess. Please be seated. The record will show the presence of the jury, the defendant, and all counsel. Mr. Martinez, you may continue with your closing argument.
Defendant had made her way to Pasadena along with her will to kill Mr. Alexander in the evening of June 3rd of 2008. And she stopped at the Starbucks, and after stopping at the Starbucks, or as part of this stop, she decided to fill up. And we know that she had the 3 gallons of gas, or the 3 gas cans at that point, based on the receipts that are before you. And the reason that she had those gas cans filled is so that now she was prepared to make it all the way through Arizona without having to stop for gasoline. And she, on her direct testimony and also part of cross-examination, indicated that, well, the car, for whatever reason, had a bad engine, for lack of a better term. It kept using gas so much, trying to manipulate you into thinking that she stopped at a number of places and used all the gas in the gas cans. But there are no records or any other corroborative evidence that indicates that she stopped anywhere here in the state of Arizona for gasoline. So her plan, if you will, was working well at that point. She wanted to kill him. There was no way that anybody would be able to say that she was even in the state of Arizona, because the defense would have been, well, I would have had to have stopped for gas. And there was no indication anywhere, and there is no indication anywhere that she stopped for gas in the state of Arizona. Another thing that she did as she came into the state of Arizona is she turned off her telephone. And this telephone, the cell phone that she had, was turned off so that it could not be traced by law enforcement. So now not only do you have her in a vessel, an automobile that will not be traced to the state of Arizona, you also have her with a telephone that is turned off. She gave several reasons to different people as to why the telephone was turned off. One of them that she gave to Ryan Burns was that somehow it had lost its charge, and that she had lost the charger, and somehow she'd been able to buy it at some store. That was her story, and then she was able to charge the telephone so that she then was able to call him near Hoover Dam. Another story that she gave was that, well, when she stopped on the side of the road and she was cleaning up from killing Mr. Alexander, she actually was able to go underneath the seat and find the charger. Either way, the net effect of that was that as she came into Arizona, there was no electronic trail of her being here, and there was no physical trail of her coming through. And this was done for the purpose. She knew that she was coming to kill him. There is no other reason why you would turn off your telephone as you're coming through here, especially this woman who clearly loved to use her telephone, but for this particular trip, for this time when she's approaching Mesa, telephone is off. And it doesn't come on until sometime later near Hoover Dam, again indicating she was never in the Mesa area. And without the electronic trail, it would have been difficult for the police to find that out. So now you have her in a position where she can come to Arizona and no one's going to know. She's in a car that's white, not red, so the police are not going to stop her. And she shows up with a gun and a knife. And she shows up to see Mr. Alexander. And if you remember that one of the things that she told the police officer, she always, whenever it was not to her benefit, would say, well, no, I was lying then. As if somehow that's a fallback position. As if somehow that's something to be rewarded. That, oh, I lied. So because I have admitted that I lied, you should put that in the good column. Forgetting that she lied to start with. And she lied to cover up the killing. And so she indicated that to this officer in a telephone call, and by this officer I mean Detective Esteban Flores, that she knew the code to his garage, 0187. And so she knew the code to the garage, and she indicated that that's how she came in. She didn't knock on the front door, she didn't go out through the back and peep through the sliding glass doors like she'd done before. She actually walked in. There's no indication that Mr. Alexander came to the door. And this was sometime after 4 o'clock in the morning. And as she came in, one of the things that's telling about what happened is that she said, I came in and I stood by the door and I watched him. And I watched him for 30, 45 seconds. Who does that? Who comes in and stands there? Someone with some sort of stalking behavior in their past? Someone who's arriving there unannounced? Someone who is there to surprise Mr. Alexander. Mr. Alexander happens to be awake. He's got the dog Napoleon with him. And the dog barks. And there's this, hello, how are you kind of thing. And at that point, she says that either she does bring her stuff in or she doesn't bring her stuff in. She may have brought her camera at that point. And we also know that she brought in her purse. And her purse is big enough for this toy-looking 25 caliber handgun. It's also big enough for a knife. She comes in and according to her, they go to sleep. There's no sexual activity between them at that point. If Mr. Alexander was this sexual fiend that she has attempted to portray, why didn't he just force himself on her there? And she said, well, at that point I told him that I was tired and that I did not want to have sex. So whenever she said no, Mr. Alexander abided by that. The only time that she ever indicated that no, she didn't want to have sex with him, he abided by that. And they went to sleep until the next day. The next day, they do engage in some sexual contact. And there's such a stigma that the defendant has attempted to attach to this particular encounter. In fact, she goes so far as to speak with Richard Samuels, Dr. Richard Samuels, and tell him about this. And tells him that these photographs were actually taken while she was straddling Mr. Alexander. Additionally, she talks about how Mr. Alexander has on his computer all these photographs of women's breasts. Just has to add all of this to make Mr. Alexander be something that he is not, or have this encounter be something that it isn't. He did not go to Wairika to seek her out. She drove here to the state of Arizona, to Mesa, to see him. Yes, he did have a camera, and yes, it was used, and thank God he had the camera, because that's the reason why we're standing here, because of the images captured on that camera. And so they engaged in this sexual contact. And there's this, again, this religious sort of overtone, somehow that she's holier than thou, that it was all of his, at his request. It was all about him. It was nothing about her. And that he's somehow violative of the concepts or the precepts of the Mormon faith. Why is that important? It's important because she wants to manipulate you. She wants you to believe that, wow, he's such a bad guy. He's holding himself out to be a virgin. And somehow that's really, really bad. That when people date, or when people talk about their sexual lives, they somehow don't want everybody to know everything that's going on. If you remember, Deanna Reed indicated that, yes, they had transgressed. They had engaged in sexual contact, but they went to see the bishop, they got whatever penance or whatever punishment or whatever happened, but they never engaged in that contact again. Somehow the defendant wants to make it seem that Mr. Alexander kept constantly going. He was this individual who had lost his priesthood or had not, had or had not. And somehow that this encounter was a microcosm of their whole relationship. Well, if it is a microcosm of their whole relationship, then we have the willing partner sitting right here. Somebody who enjoyed it just as much as he did. One hand or two hands, she enjoyed it as much as he did. There are no indications in those photographs other than from their experts who say, look at the face. You can tell by the face that she really doesn't want to be there. Really? Can you tell by a grimacing face whether that's pain or joy? Can you tell that by just looking at somebody's face, especially if we're talking about a sexual situation? You can't. But they come in and they want to tell you that because they have a psychology degree or they have a master's degree. And they want to tell you that. Don't believe what you see in your eyes. Don't use your common sense or the experiences that you have coming in here. Believe what we have to say. And by looking at those photographs, you can see that this was all about Mr. Alexander. And again, that's just a microcosmic view, if you will, of this whole relationship where she says, I really never wanted to do it, but it was all about him. And yet, if you look at the photographs, there's no indication there that she really didn't want to do it. She was enjoying it as much as he was. And so they engage in this conduct, these two Mormons. So stop pointing a finger at him and stop wagging it as if somehow being a Mormon precludes you from being human. So stop pointing a finger at him and stop wagging it as if somehow being a Mormon precludes you from being human. If somehow that's something bad that he did it, because she's just as Mormon as he is. So if there are fingers to be pointed, it should be pointed at each other. And if one's conduct is bad, the other one is just as bad. But that's not what this case is about. And they want you to think that that's what this case is about, that this is about Mormonism and the fact that Mr. Alexander was engaging in sexual intercourse. What those photographs show was that she was there. And they show you the time that she was there sometime after 1 o'clock in the afternoon. And so you know that at about 1:30, they are consummating, if you will, their feelings for each other, at least on a physical level. No indication there of anything else other than perhaps Mr. Alexander has adopted what the defendant has provided for him, because you do see the KY bottle in some of those photographs. And you do know who introduced that into the relationship from the May 10th, 2008 conversation where Mr. Alexander thanked her for introducing him to that. We don't know who brought that on that particular day, but it could be reasonably inferred, we're not saying that it happened, that she brought it. She's the one that introduced him to it. Perhaps he already had it there. Either way, that's symbolic, if you will, of her attentiveness to this sexual, perhaps he already had it there. Either way, that's symbolic, if you will, of her attentiveness to this sexual relationship that they had. And so, later on in the afternoon, toward getting later, sometime after 5, the defendant says, and it depends on what you listen, or what version you listen to, that at that point, Mr. Alexander wanted to show off his body, according to her. And he wanted her to take photographs of him. You've heard the tape of her conversation with Detective Flores. That was taken when, and how she loved the way he shaved because it was old-fashioned. And then she starts talking about how, yes, she is able to get him to get into the shower and take photographs of that. And it really is. And then she starts talking about how, yes, she is able to get him to get into the shower and take photographs of that. And it really is more of her idea than his. And the only reason that the state can say that it is really more idea than his is if you hearken back, think back to what Darrell Brewer told you. One of the things that he was asked on cross-examination was, when he was on the witness stand, were there ever any photographs that were taken of you by the defendant? And he said, yes, only on one occasion were there photographs taken of me. I didn't want them taken. I was in the shower when she started to snap the photograph. Wanted me to do it when, as part of the same case, you have her saying that, no, he did not want her to do it. But she then starts taking photographs, and according to her, very sexy. But at that point, the ill will was already there. She is armed with both a knife and a gun at that point. And she begins to take these photographs. And as she takes these photographs, even though she says they are of a Calvin Klein kind of quality, the water coming down as if it was sort of a Pacific, a very quiet, bucolic kind of scene. That's not what's going on. She talked earlier about a knife, justifying how a knife would have been upstairs by saying that there was this 20-foot rope, and that somehow she was tied up with that 20-foot rope to that bed. And it depends on who she's talking to as to whether or not she was tied on her ankles as well as her wrists. But you've taken a look at that sleigh bed. Where is she going to be tied up on that bed? Making it up, trying to justify, or trying to have a knife there for some other purpose. But if you take a look at that bed, and you've seen it, you know that she's making it up. Just making it up. If she's not making it up, then why has she told some of the experts that she was tied by her ankles or on the foot of the bed? Why does she tell somebody else that it was both her ankles and wrists? Why does she need to keep changing positions? Because she has a lot to remember. And with the truth, you ain't got nothing to remember. But she has a lot to remember. And it's a lot for her to keep straight, given that she's making all of this up. And so, given the facts as we know them, and the fact that there was no rope, because it would have required her to clean up in the bedroom, because that's where the rope was. And if she was all bloody, because we do know that the floor was all bloody, it was also very wet. It was either wet with water, which is white, or it was wet with blood, which is red, Mr. Alexander's blood. It would have required her to go into the rest of the bedroom and leave some trail of that. And there's nothing there. So it means there was no rope there, and there was no knife there for her to get. It means that she had both the knife or at least the knife at the time of the attack. And so what happens then is that she's standing there, and then we have this photograph. Exhibit 160. This is the last photograph of Mr. Alexander. This is the last photograph of Mr. Alexander. There, not only is he defenseless, he does not have a gun, he does not have a knife, he doesn't have any weapon whatsoever. Not only does he not have that, he doesn't have any clothing on. And as he sits there, he doesn't have any dignity either. She's taken that away from him. And if anybody, and as he sits there, he doesn't have any dignity either. She's taken that away from him. And if anybody is defenseless, in this case, It isn't the defendant. It's Travis Alexander, as he sits like that in that shower with his killer standing there dressed in pants, presumably a top on, because there's no indication that she didn't have a top on, with his camera. And she starts snapping this. Part of the story of hers that you would have to be in the sharpness of this photograph. There's nothing accidental about this. Somebody held the photograph, or the camera, firmly. The defendant held it firmly as she pressed the button and took this photograph, the last live photograph of Mr. Alexander. And while she had that in that position where he is in the inferior position to her, he's down, she's standing up. She can approach him, and she can approach him as he's sitting there. And she did. No doubt about that. This is not a case of whether or not there was an attack here, whether or not it wasn't her. It's her. And it's him. And it's the man that she has just had sex with. And it's this individual that she has planned to kill all the way from May 28th of 2008, days, even though the premeditation statute only requires a certain period of time. It doesn't require days, doesn't require planning, requires thinking. And so, she's been thinking about it for a long time because she came very prepared. And before she even went in there, one of the other preparations that she took was to take the license plate off the car. So now she's inside, now she's got him like that. Can anybody think of how anything else could be so much colder or without feeling for the person than to make...
Objection, Your Honor. Your Honor, verbal argument.
Approach. Approach.
It is cold. It is thinking. It is premeditated. To go up to this individual, someone that she has planned to kill for days, someone with whom she has been intimate with, and then attack him. She has indicated to you that it was a shot to the head, but the evidence, the forensic evidence, speaks otherwise. And for you to believe her, and for you to believe that the shot was first, you will need to set aside everything that she's told you, for example, the gas cans, everything else that she has told you, including the fact that she lied to the police, including the fact that she lied to the experts, including the fact that she lied here. And then you have to say, even though she's lied all of these times, even though she's looked us in the face and lied to us, we're now going to believe her with regard to just this one particular aspect. That is not something that is available to you, I submit. And I submit that because of everything that she has said. And so she gets her knife. And she took that knife and stabbed him right front here. The reason that we know that she did that is because Mr. Alexander has defensive wounds. And he has defensive wounds to his left and to his right hand. As she is stabbing him, he is alive, and he is cognizant of it, and she begins he begins to grab at the knife. But unfortunately for Mr. Alexander, one of the knife wounds is to the heart. Doesn't mean he's going to die immediately. It means he's just going to die. And part of the dying process includes, because of it's the heart, blood coming from his mouth and blood coming out from the wounds. But he's not going to die immediately. He's going to take some time, minutes, to bleed out. But he is going to die. So in a sense, she has already killed him. He's dead. Well, you know that he gets up at some point. You know that he doesn't remain seated there. Because throughout the bathroom, or where there's the mat, where there's the scale, all around the bathroom, everywhere, there's blood. And if there's blood everywhere, that means there is movement there. And it isn't the kind of movement that is the flopping of the fish kind of movement. It is movement, it is purposeful movement on the part of Mr. Alexander to save his life. And as this time is going by, again, premeditation does not take days. Premeditation does not take a plan. Premeditation just takes time. And it can be a shorter amount of time. The stab wound, for example, after the first stab wound, it could be that. And as he is in this position of dying, he then ambulates. And we know that she didn't carry him over to the sink. We know that he goes there by himself. And one of the things that you see there is this, 98. That's the sink. And that's the sink with his blood on it after he has been stabbed. The reason that you know that he has already been stabbed at this point is because of the patterns that you have on this particular photograph. Right here on the left. And remember the injuries to the hand. He had more stab wounds to the left hand than he did to the right hand. And one of the patterns that was described here was this smudge or this transfer. So that if he, and remember, he had more injuries to his hand. That's not something that she can tell you he doesn't, but you've looked at the photograph. You don't need to believe that. You can believe the photograph. And he does have an injury, a slight injury to his right hand. But if he's standing here, this would be where his left hand is. And you can see that there's the smudge or the transfer as he moves that way, as he's falling, moving away, indicating movement. He's still alive, but he's bleeding. That red stuff there, it's blood. And you also have the drops here. And those are placed there by gravity. If this individual has blood in his mouth, and if you remember that the medical examiner testified that if you do have an injury to the heart, that's one of the things that happens. And as it requires Mr. Alexander to be standing there with his left arm like this. And as he's doing that, you do know that this is what's happening to him. She is stabbing him in the back. That's exhibit number 192. That's a concentric area. Exhibit 193 also shows us that. And he's also being stabbed, as you saw, in the back of the head as he stands at that sink. Because he is standing at that sink and he is bleeding, and the amount of blood that's at that sink is indicative of time. You just don't go over for a second and get those patterns. He stood there, which means that the defendant was there with the knife, stabbing him. The other pattern that you see there is this, on the mirror. If you remember, the blood spatter person indicated that, well, yes, that can happen from For example, gunshot wound, but it can also happen if somebody has blood in their mouth and they get hit in the back of the head. And that's called blood spatter, high velocity splatter. And what that means then is that Mr. Alexander was having some force applied to his head at the time that he was standing there. That's how you can know that Exhibit 193 occurred when he was standing there and the strikes to the head. Because the splatter that is on the mirror indicates movement. It's hitting him. And then he goes and flies into the mirror. But he's not dead. He's still standing there. This woman that came to visit him came prepared though. So he begins to go in a different direction. And we know that he begins to go down the hallway, and he's still standing. The reason that we know that he's still standing is if you take a look at Exhibit 133. That's a blood transfer. It's either an item with blood came by or the blood was already there. Well, the item with blood in this case was Mr. Alexander. And as he's going by, you can see he was still sort of standing. And in this rainbow, somewhat ironic, there is no good luck for him at the end of that rainbow. But you can see that it starts high. And it arcs down to the area where there's the larger amount of blood. He's stumbling down that way. But he's stumbling with somebody after him. He's trying to get away. He's trying to get away from her over there. And she may cry now. But the jury instructions have told you that sympathy is not to be considered in this particular case. No doubt that she did it. No doubt that he's trying to get away from her. And you can tell that by the arc that is there. You can see that even clearer. And here, with regard to Exhibit 132, that's the same view. Let me show you the arc there. Just for contrast, to show you that that was part of what was going on, if you take a look at the other side, the other wall, you can see that these are more at the bottom, indicative of substance with blood either rubbing it there or the blood already being there and an item going through there, as opposed to this arc that we see here. She chases him down. That's what she did. He's still alive. How many stab wounds has she already given him at that point? The ones to the back? Do we really need to count the number of stab wounds to get? Is there a requisite number to get through the portal of death? No, not really. There's enough here to get him there. He's already got the one to the chest, which is going to kill him. He's already got the ones to the back of the head. They're not failed. And he's got the ones to his back. But they are accelerating his departure from Earth. Because the more he bleeds, the quicker he dies. He don't die immediately. And so, when he gets here, to the end of his rainbow, gets there to the end. And when he gets there, that's what she does. This is exhibit number 205. Slits his throat from ear to ear. Number 205. Volition, by his own movements, as he tried to get away from her. You know that because of the bloodstain pattern. You know that because of Exhibit 130, which shows you. And remember, the rainbow is right above there. He goes down, he collapses there. She catches up to him, and goes for the throat. Is right above there. Goes down, he collapses there. She catches up to him and goes for the throat. And if you want to believe her that she doesn't remember anything, doesn't know anything that's going on, why then? Why then, if she really doesn't know what's going on and can't remember, why is she so directed at a place where she can certainly cause death? If she really didn't know what was going on, if it was just really passion, if it was just a heat of passion, then you wouldn't have a directed hit to somewhere that's going to kill. You would have dispersed all over the thinking, this person's not going to live. He may get away from me in the shower. He may get away from me all the way to the sink. And he may stumble his way down that hallway. But you know, I caught him. And now, rather than stabbing him anywhere else, right here. So it's a very well orchestrated kill. And it takes time. By time, when somebody takes time, people think. So she's now stabbed him in a die. When somebody takes time, people think. So she's now stabbed him in a die. Now he's tried to get away, went to the sink, and what's almost something to consider, another thing to consider while he's at the sink is that in front of the sink is a mirror. And as he's standing there, a mirror is reflective of what's going on behind him. And he has eyes. His eyes are still open at that point. He can see. He can see the defendant. But she's not done with him yet. And again, the point here is that if this were a heat of passion, if this were a situation where somebody was just upset, it would be random all over the place. But this was a strike to kill, right at the neck. And then, after she does that, one of the things that we know is that the shooting didn't take place there. The shooting took place near the sink, where he had previously been standing. And so, one of the things that they wanted you to believe was that if this person is shot and hit through the head, could have been shot there at the sink, according to them. He's already bleeding and still continued on. But the knife wounds do have to be first. Of course, that would violate the laws of nature because he's bleeding so profusely there that the doctor, by necessity, would have had to have found lots of blood in the track of the bullet, and he didn't. So if he was standing at the sink and he was shot at the sink after being stabbed, there would be lots of blood there, and the doctor did not find any there. So he clearly was shot after that, when the situation was such that his heart wasn't beating, in a situation when the heart wasn't pumping enough blood to get it there. Bottom line, he was dead at the time that he was shot, in order to forensically get the result of no blood in the track of the bullet. So he falls there. And then we have more directed behavior. We have this, exhibit number 162. That's Mr. Alexander, that's blood, that's his foot, and that's her foot. And given the fact that we know that the bathroom is this way, that's her standing there. And what's important about that, if we look at this exhibit here, is that it looks like there's been a wildebeest migration near his head. Look at that. And what's important about that is that even though there is the stomping of the feet, it just means she was over him, hovering him. How many times was she stamping around or stomping around there to get that pattern? But what's even more important about that is that there's nothing in the bedroom, which means that this was directed behavior at him. She was cognizant of what was going on, because if she would have been in this state that she wants you to think that she was in, then it would have been all over the bedroom. If she'd have been in this hysterical state that she describes for you, that she would run out, run into the bedroom, except it's in pristine shape. What she does then is she begins to drag him. And again, we look at that one, and then Exhibit 163, which is a bit later, you can see she's dragging him down the hallway. What that shows is an intent, or an attempt, to clean up. And as she's going by the sink again, you know that she does something else. When she does this, Exhibit 207, shoots him in the head. There is no blood in that blood tract, which means the heart isn't pumping. And when the heart isn't pumping, he is dead. There is no other medical phenomenon or any other medical indications that would give any other indication. And if that's the case, then he's already dead. And then you have the casing from the .25 caliber handgun that she took during this staged burglary. And then you have the casing right there, falling on top of the blood as she's dragging him back, because by necessity, the body has to be there. And if you remember, there's a closet that's up here, the sink is to the left, and the sink is to the left, and this falls to the right. One of the things that we've talked about is that the shot just right here. If she is dragging him in this fashion, that way, and she's pulling him along here, that would mean that it would be this portion of the head that was exposed, which if you're pulling somebody down the hallway, that's the result that you get. The casing is expelled and it lands on the blood that's already there. So that's when she delivers this shot to him, somebody that's already dead. So she's killed him 3 times over. Is that enough premeditation? Even though she's had all of this planning already, this was a very directed attack. And then she goes about the business of cleaning up. And one of the most interesting things about the cleanup that she did is that, she knows about cameras. She knows what to do with cameras, according to her. And one of the things that she knows what to do with them is delete photographs. And she's able to look at all of the photographs that are on this camera. Let's assume, for example, that they've already deleted the ones involving the sex. This one right here, the inadvertent photographs, Exhibit 162, for example, had to be deleted after he was dead. There's no way to get it. There is no time travel here, because that's really what they want you to believe. After this happened, she located the camera. And he's not carrying the camera as he's trying to survive. He couldn't care less about that camera as he's standing over the sink. So what does he do? He just tries to get away. So the camera getting there means that she is the person that was holding onto the camera and carried it to that location. Then, after she shoots him, she goes back, places him in the shower. At some point, either after shooting him at the sink or after placing him in the shower, at some point, she's still thinking. Because remember how much she has planned before. I've got to get rid of this evidence. I've got to delete this. And what does she do? She deletes only certain images. It's not like all of the images are deleted. This shows somebody who is thinking, oh, I don't want to delete the one of his dog. or this other one, I'll delete this, the only ones that hurt me. And that is directed behavior by somebody who claims to have dissociative amnesia. Dissociative amnesia, you heard what the definition of that was. Or is it a fog? Even the San Franciscan fog, if such a thing existed, wouldn't be so cloudy to account for this kind of behavior. There is no fog that someone can tell you about that hasn't lifted to allow for this. And so she cleans that up. She has that, and she cleans that up. The other thing that we know is that she takes the camera at some point from that area there. And again, what's important about that, yes, it's important where it was found, and yes, it's important that it was found in the washer, but what's actually more important to show that she was thinking is that there are no steps leading from the bedroom down to the area where the camera was found that are bloody in nature or red, which means that she was cleaning herself up. Because if you're going to be walking around there, you by necessity are going to get it in your socks because that's what she's wearing. She would have had to get it on her socks. And if she's in this horrific hysterical state, she would have ran down and thrown it down there. But what she did is she cleaned herself up first. The police did not, and you looked at all the stairs, did not find anything that showed that there was any activity other than up in the bedroom, which means she cleaned up. She took her socks off and then maybe put her shoes on or maybe put different socks on. But definitely the item that she was wearing was taken off before that camera was taken downstairs and put in the washing machine. And it was put in the washing machine and put through a cycle. Oh, there's this big indication, or this indication she could have taken it with her. So, what does that mean? It just means it's an alternative. But she has done so much already. Other things that she has done, according to her, is there was this glass underneath the sink area. And that's the glass that's found on top of Mr. Alexander after she cleaned him up. After she cleaned him up in the shower. We don't know if the glass was an afterthought or if it was used to actually clean him, but actually shows that she went to the sink, approached his body, and dropped it on top of him. But she cleaned him up, wanted to wash away anything or any contact or anything that would show her being there. Again, we're told about what DNA is and how it's left behind. But if somebody washes it away, it's just not going to be there. And that's another step that she took in staging this scene. She washed away all of her DNA from him. Could have turned on, we don't know if she turned on the shower. We don't know if she used the glass. But we do know that she cleaned up. And it isn't because she loved Mr. Alexander that she cleaned him up. Oh, it isn't that she wanted him to look good, even though he, with all due respect, he looked a little bit crunched up there. It wasn't that. The net effect of what she did is to destroy any of her DNA. She washed it off. That's what people do when they want things that, such as items off their hands, they wash out. And that's what she did. And then we don't know what was in the middle of the bathroom that was causing her concern. But we know that she focused in on the bathroom area as well as near the closet. Again, we don't know exactly what was there. Perhaps that's where she dropped the knife and she needed to clean the knife there, because we know that the knife was cleaned. We know that the knife was not left behind. So again, there's this directed behavior with regard to the knife. Had the knife been dripping blood, and remember, she had just stuck it into his neck. Had that been happening, and had she been in this hysterical sort of mood that she wants you to believe, it's fair to say that that knife would have been bloody. She would have dropped blood along the way. No, she carried it out. She wants you to believe that she may have carried it down to the dishwasher. If she did carry it down to the dishwasher, which the state disputes, but we can use that for demonstrative purposes to show that knife, if it was carried downstairs, either had to be cleaned up upstairs or wrapped in something like a towel, which shows again directed behavior, so that no blood got on any of the stairs. Didn't get anywhere else. So if she says, which is what she said, that sort of alluded to, that maybe that's what she did with the knife, because no knife was found up there, and we do know that a knife was used in this attack. If she did that, she did something with the knife. She either cleaned it, stuck it in her purse, or according to her, even if you put it in the dishwasher, but she can't be sure about that, the behavior before the movement of the knife shows that she was thinking this whole thing through. If you step back and you say, what was she thinking at the time? Well, she was thinking of staging the scene, cleaning it. That's what she was doing. She cleaned the body of any DNA. She cleaned the area where it appears some of the attack occurred. The other implement, the knife, that was clean because it wasn't found or dripping anywhere. The gun, well, it was taken. The clothing that she had on her, specifically the footwear that you see in Exhibit 162, that wasn't found anywhere. There was no bloody socks anywhere. And even the towels that were upstairs, if you remember, there was one towel missing from the set, was taken down and placed inside of the washing machine, and the cycle was run. It appears that the cycle was run with Clorox. And what's significant about that is that, yes, it's significant that Clorox was used, but what's also significant about it is that the hands were clean at the time the Clorox was grabbed, because otherwise you would have seen the handle with blood on it, you would have seen blood all over the washer. You didn't see that. She had already cleaned up upstairs, and she was cleaning up because she did not want to get caught. And it was actually, as plans go, pretty good, except for the photographs. So she's now staged the scene. She's now cleaned up. There has been days of premeditation, but if you just take the scene itself, and we will discuss the jury instruction that tells you that it just requires a space of time. And killing somebody 3 times over has built into it a space of time, irrespective of which events you think happened first or happened last. It's the state's position that the stabbing happened first because of the forensic evidence and the blood spatter evidence that's upstairs. Either way, she killed him 3 times over. She stabbed him in the heart. He would have died from that. Certainly the throat was immediately fatal, and the gunshot would also have been fatal. So there is this premeditation aspect. And so she staged the scene at that point. Then she did some other things that were equally as interesting. And by interesting, I mean demonstrative of how well she was thinking at the time. She claims that she was in this sort of foggy state. She wasn't in such a foggy state that she couldn't put the license plate back on the car that she was driving on the back. She was in a hurry and put it on upside down, but she had already taken it off before and remembered to put it back on, such that she drove all the way to Utah that way and was stopped in West Jordan, Utah. So yeah, she was thinking there. She wasn't driving without a license plate, because police officers would have stopped you quicker without a license plate than one upside down. So thinking there. The other thing is she packed up the clothing that she was wearing. It was bloody. The socks included. Packed all of that up and took them with her. Cameras, her purse, the gun, all of that. She was cleaning it up, staging it up for the police, so that when the police went up there, they wouldn't even know what was going on. Got in the car, did all the cleaning, and was sure and careful not to get it anywhere other than the bathroom. Walked out, and then on that hot summer June 4th, got into the car, left Napoleon behind, and started to drive away after putting the license plate on the car. And, according to her, at some point, filling up with gas from the gas cans. If you're in such a fog, how can you even remember that you have gas cans? How can you possibly even remember that you have a gas can if you've never done it before? And she, according to her, this is not something that she did on the usual basis.
Objection. That's not an evidence.
Overruled, the jury is directed to recall the evidence.
And away she goes down the road until, according to her, she stops on the side of the road, starts calling Ryan, and continues her lies. Starts calling Ryan and saying, and gave a story about where she had been. She lied to him. She wanted to continue that, speaking with him because he could potentially say, well, no, she was with me. She was somebody that was with me at the time. So, again, she's continuing to stage the scene for the police. What else does she do? If she didn't think that she had killed him, then why is it that she's calling and leaving a voicemail message as soon as she possibly can? Oh, I'm sorry, I couldn't stop. If she was really in this state of fogginess, you would have heard some mumbling, or she wouldn't have been able to work the prompts on the phone. But she was able, according to her, keep going back and try to do the message. 1, 2, 3, 4. How many times did she say? Many, many times. She said she tried to do that. That shows some clarity of thought. And of course, though, she wants you to believe that there was no clarity of thought. She wants to manipulate you, wants to continue to lie. Why send an email? If you really didn't know what had happened, why send an email? Why not call the police? And why continue on your journey to make it seem normal? Why continue to make it seem normal? As if nothing had happened. The reason that you do that is because you had it planned. Ryan Burns was nothing more than her alibi. She showed, maybe he was a little bit more because of the interest that she showed. But she calls him up, makes up this story about where the cell phone has been, and continues on to Utah into his waiting arms. Gosh, you could almost hear the violins making their sound as she goes up to him, gives him that first kiss. Isn't that romantic? And then later on, as they kiss passionately after going out, and she adjusts him, whatever that may mean, although according to her, he's full of crap. Anybody that doesn't agree with her, oh, they're full of crap. Those are her words from the witness stand. He's wrong. And he's not telling the truth according to her. He doesn't have anything to gain. But he does tell you that, yes, they were involved, and they were involved in a sexual fashion when she gets up there. What a wonderful reunion, what a wonderful time it must have been for her. And so then, there's this talk that she has with her friend Leslie Udy. And she begins to talk about the future with Mr. Alexander in it. How this Mr. Alexander that is going to be with her in the future after he's married and he has kids. She's married, she has kids. Their children are going to play together. Absolutely staging the scene again. Continually staging the scene so that if the police start making inquiries, guess what? Well, she didn't know he was dead. Boy, she was just normal with me, Mr. Burns would say. And with Leslie Udy, oh, she was talking about the future. Again, she's just staging the scene after what she has done. At the restaurant that they go to, there's this talk about her hands, and she, again, makes up a story as to how she got the injury to her hand, even though it's from the knife slipping as she was knifing Mr. Alexander to death. And then afterwards, her friend, Dan Freeman, calling her on the telephone and telling her, oh, his body has been found. And she, crying, then calls the bishop, trying to determine whether or not he was alive. What an absolute facade. She's creating a wall of excuses, a wall of absolute, what appears to be impenetrable might, so that no one can assail her. No one can say that she had anything to do with this, because she's acting the part. And she's lying. She's making it all up. She has lied to everybody, and she has staged the scene. She staged the scene of the murder. And then she came into court, and during these proceedings, has staged her defense. And she staged her defense by lies. And the lies that she told were to a number of people and to various groups of people. First of all, let's start with you. Perhaps it may be that in court, because of the admonition and standing in front of the clerk, that somehow that would bring out the truth, because after all, this is a truth-finding sort of proceeding. Well, let's start with some of the examples that we can talk about that we know that she lied to you about. This issue about the gas cans. absolutely, without a shadow of doubt, she's a liar. And she's a liar about, number one, that she returned it to Walmart. And she's a liar about the fact that she didn't have them with her in Salt Lake City. It's just a lie. And the reason she's lying is that that explains why there are no receipts here in Arizona. And that also goes to premeditation. She planned to come and kill Mr. Alexander with that .25 caliber and that night from May 28th on. That's what the evidence shows. One of the things that you can say to yourself, well, you don't have any direct evidence of that. That's true. We have circumstantial evidence. And circumstantial evidence is a fact that you can deduce from looking at the circumstances as opposed to direct evidence, which is visual or hearing, sensory kind of evidence. The best example from looking at the circumstances as opposed to direct evidence, which is visual or hearing, sensory kind of evidence. The best example, no matter what time of year it is, and you're there by yourself. And you're standing there and you're watching the waves come in. As you stand there from your left, somebody walks by and then goes to your right. A minute or so later, somebody else comes to you and says, has there anybody else been on this beach? And you can say, sure, I just saw him walk by. That's direct evidence. Well, contrast that with circumstantial evidence. You are at the same beach. You have not seen anybody go by. You have not seen any fingerprints. You haven't seen anything. And you decide that it's a nice day and you're going to close your eyes. With circumstantial evidence, you are at the same beach. You have not seen anybody go by. You have not seen any fingerprints. You haven't seen anything. And you decide that it's a nice day and you're going to close your eyes. You have your Wayfarer sunglasses on. You have your towel out. You're going to lay down and you close your eyes for exactly, let's say, a minute. And before you closed your eyes, you noticed that there were no footprints here, no footprints in front of you, and no footprints there. And the ocean's not coming up to you. Close your eyes and you wake up, and for those 45 seconds or so, and then you look, and to your left is a set of human footprints. You see it goes right in front of you, and then it goes by. You didn't hear anything, you didn't hear anybody, but you can say yes. And the reason that you can say yes is because of the footprints that you saw after you woke up. And the same thing here. There are many footprints to this premeditation aspect. One of the footprints that we have is up in Wairika, California, after the May 26th, 2008 argument where he tells her, you're the worst thing that ever happened to me. Then you have her stealing the gun, or the gun is stolen, and it's a .25 caliber that's actually found at the scene. After that, you have her borrowing some gas cans, and then you have her lying about those gas cans. And then you have her lying about the license plate. And you have her turning off her phone so that she can't be found in Arizona. And then you have the photographs, and you have the rest of the evidence in this case. She premeditated the murder in this case. The other thing that we need to talk about in terms of what she told you that is not true is why she rented the car in Redding. She said, oh, that's the place that Priceline would give her the best deal. But you saw the receipts, not the receipts, but the statement from Washington Mutual that indicated that, hey, she paid directly to budget. So that wasn't a Priceline thing. She looked at each and every one of you. And that's what she told you. Well, that's because, of course, she's innocent. And you as a jury are not going to convict her, right? The other thing that she talked to you about was this injury to her finger. She said that she showed you the finger and she demonstrated it to you. And she said that Mr. Alexander had been the person that actually had done that to her. Well, if you remember during cross-examination, when she was being asked about what happened in her killing of Mr. Alexander, the question was, well, you really didn't get any injuries. I mean, aside from the injury to the head, do you remember? That's all that you got there. And then she said, oh no, I also got the injury to my finger. Do you remember her saying that? In a moment of candor, in a moment when she wasn't quite expecting it, she said, yes, that's when it happened. Yet then she turns around and says later, no, that's not how I got it. I got it working for Casa Ramos, Margaritaville. I got it at his house. Who knows? But she looked at you straight in the face about an event that occurred at the time of the killing. And she looked you in the face, every single one of you, after taking the oath and lied to you. Maybe this law of attraction, maybe something else, maybe that will explain it, or maybe her experts will explain these 3 areas that you know were made up. She just made them up to you. And why did she make them up? Because although she says no jury will convict her, it's because she's attempting to get you or manipulating you to get to that particular point. One of the other things that perhaps we need to look at or talk about is their experts. And with regard to their experts, and with regard to the defense that's presented, one of the things that perhaps you can sort of allude to and maybe make reference to when you're looking at this particular defense is by reference to Elizabeth Barrett Browning in a sonnet, where she indicated that, and again, it's just a reference to it, how do I love thee? Let me count the lies. It's a little bit of a reference to it, but that's not exactly what she said. But really, how do I love thee? Let me count the lies. Well, we've counted 3 so far that in this court, looking at each of you, she said that. What else can we look at? Well, perhaps we can look at the motivation, or perhaps we can look at people that have testified on her behalf, and maybe we can understand what's going on. We can talk, for example, about Alice Laviolette. She's the person who has a master's, who came in and has been doing this for a long time. And one of the things that Alice Laviolette has, and she has an extensive CV or resume, is one of the things she hasn't included in there is that she is also a liar. That is just the bottom line. She came in here and she told you, in response to one of your questions, about whether or not she had ever testified on behalf of a male in court. And she said 1 or 2 times. Remember that? And when she was pressed by the prosecutor during cross-examination, well, who are they? Couldn't give me the name. Give me a name. Go ahead, give me a name. Pressed even further, she said, well, I didn't testify. I actually wrote a report. She wanted to make herself more than she really was. She also talked about being a keynote speaker at one of the conferences where was Snow White a battered woman. She indicated that she was one of the keynote speakers there at one of those conferences, and she wasn't. Her CV indicated that she was on the plenary panel, which is just part of people that go there, and she made a presentation to a smaller group. And just as importantly with regard to lying and Alice Laviolette, she indicated and tried to justify the defendant's lies for you so that you wouldn't think that they were so bad. She kept saying, well, she lied before, but not afterwards. And we got into this conversation about lying, and Alice Laviolette said, well, you know, bad. She kept saying, well, she lied before, but not afterwards. And we got into this conversation about lying, and Alice Laviolette said, well, you know, there are such things as white lies. Those are okay. See, you don't understand. For her and for the defendant, white lies. White lies. They're okay. And if it's to her benefit to say that something is a white lie, she will say that it is a white lie. And in this case, everything that's negative towards the defendant, and it is untruthful, well, that's just a white lie, according to Alice Laviolette. And to her, that at you as an expert, because they're trying to provide guidance and say, yes, I have testified on behalf of men before, and then going back and saying, no, that's not true. Measure, but maybe that's a guide to the defendant. Maybe that's something that she, of course, believes. Maybe that's something that buttresses the defendant's case, and Alice Laviolette believes that that's something that she should do. But what that indicates is that she's nothing more than an advocate. When you begin lying on behalf of the person that you evaluated, when you begin to visit them, when you begin to give them books, when you're with them for 44 hours, that line was crossed. Anything Alice Laviolette said is contaminated. It is foul. It is not something that you should consider. Because how much credibility can you give her if she came up here and in advocating that position, she lied to you? Absolutely no worth at all. And then you have Dr. Richard Samuels. And one of the things about Dr. Samuels was that and the issue involving lying is, one of the things that he did is that he had trouble with regard to this scoring and rescoring, and there were some issues as to really what the motivation was for the rescoring. Janine DeMarte, Dr. Janine DeMarte indicated that, well, there's no reason to be rescoring something 3 times unless you perhaps want to change the scores. Or with regard to the MCMI, there's no reason to submit it twice unless perhaps you might want to change the scores. But one of the things that we do know about Dr. Samuels is that he gave the PDS test. And there is no doubt as to that test that the defendant lied. The defendant made it up. There is no truth to the fact that on question 14, number 4, that whatever seminal event that they're talking about, there was never any indication whatsoever that there was a guy and a girl that came in and killed Mr. Alexander. But he based his test on that. And the defense and the questions may be asked about whether or not it involved the attack of a tiger, or if it involved the attack of a bear, or if it involved a gopher. It doesn't matter. The bottom line is that it's a lie. Let's say that somebody goes to the doctor, and they go to the doctor and they're talking about some sort of pain that they have. And if they start lying about the pain, isn't the treatment going to be affected by it? How good is the workup going to be if the seminal event that you're there for is a lie? Oh yeah, you can say she suffered trauma. Okay, let's assume that you can go that far and say the PDS does show that she suffered trauma. Well, which trauma are we talking about? Is it the bear? Is it the tiger? Is it the gopher? Or, in our case, is it the trauma of lying about killing Mr. Alexander? Is that what we're talking about? Or is it the killing of Mr. Alexander that we're talking about? Or, as the other expert, Cheryl Karp, found, was it the trauma of this non-existent domestic violence? The problem is that when you start lying and the experts get involved and they start basing their test on a lie, how valid can the results be? For example, Cheryl Karp found that, yes, she believed it was post-traumatic stress disorder based on many, many events of domestic violence. Yet there are only 4 that were presented to you and never linked to post-traumatic stress disorder. Then there's this test of PDS that was taken, and according to Dr. Samuels, he said, you know what? I probably should have re-administered it. In a moment of candor, he said that. And yet he then reversed his position and changed it. But again, what do we have here? Another lie by the defendant. Not only to Dr. Samuels, but also to Dr. Karp or Janine DeMarte. Dr. Janine DeMarte. Either one. You can't have a lot of domestic violence or a little bit of domestic violence. So you have that issue that is sort of floating out there with regard to the experts. The other area that the defendant lied about was the police. Detective Ford?
All right, ladies and gentlemen, 15 minutes. Please be back at 3 o'clock. 15 minutes. You are excused. Please remember the admonition.
Please stand for the jury.
We are in recess. Please be seated. The record will show the presence of the jury, the defendant, and all counsel. Mr. Martinez, you may continue.
We were talking about the litany of the defendant's lies, and we were at a point where we were going to talk about the lies to the police officers. And you've heard so much about that almost there's an effect such as, well, she did it. It's let's accept it and move on. But it is an important factor, not because it is important because she lied, but because of how it fits in to her particular plan. And one of the things that we have to think about when we talk about lies is that, and you think about what she told the police officers, is that maybe there was some exaggeration that was going on with regard to what she told the police officer, or maybe there was some minimization that was going on. In terms of exaggeration, one of the points that needs to be made is that Robert Geffner, who was here yesterday talking to you, and said, well, exaggeration really isn't a lie. Well, it is, because it's not the truth. And so some of the things that the defendant told the police officer, well, exaggeration really isn't a lie. Well, it is, because it's not the truth. And so some of the things that the defendant told the police officers, somebody may say, well, no, that's a little bit of an exaggeration, maybe it isn't. But at the time that she spoke to the police officers, it had been something to think about what was going to happen if she spoke to the police. And so it's important from the aspect of somebody who's thinking about it, somebody who is planning. It shows that this individual had the forethought to have a story ready when the police officer came to her. And this individual is of such strong will that even in the face of what the police officer was talking to her about, she would actually not budge initially when she was spoken to by the police officer. For example, one of the things that she was asked on the first interview, well, isn't it true that you were there? And she kept saying, no, I wasn't even there. How could I have possibly done this if I wasn't even there? And then she was asked, well, isn't it true that your fingerprint or your palm, it was actually a palm print, but the fingerprint, isn't it true that the fingerprint and blood was there? And she said, well, of course it's there. I've been there all this time. And so it shows you the adaptability and how nimble this individual is, such that when she gets in any situation, whether it be involving Mr. Alexander or here in court, this individual is quick thinking and is good on her feet, and so that when she's talking to you on cross-examination and you get those answers are designed to manipulate. And so that's why those statements to the police are important, because they show how she can attempt to manipulate things and is able to say whatever fits the story at the time. So initially, when the police came to her, when Detective Flores came to her and asked her, well, this is what we have, let's talk about it. She denied everything. And she kept saying, let me see the photographs. I want to see the photographs. The reason she wanted to see the photographs is because she wanted to conform her story to what the police knew or what she thought the police knew. And in fact, in other conversations, during the telephone conversations, they discussed it. And that just shows you this type of individual that can adapt, if you will, as she's going along with the interview with the police officer. And in asking to see the photographs, it's interesting that she asks that. And the only reason that I mention it is because previously, when I was showing the photographs of the killing of Mr. Alexander, we had the defendant crying. Well, why did you want to see the photographs when the police officer was there? You knew what had happened, and yet she's still asking to see it. Again, it's just another form of manipulation to have you feel some sympathy for her as she sits there with the red nose, face down, apparently crying. But yet, she asks the police officer, can I take a look at these photographs? The police officer, of course, did not show her the photograph. So the first story on July 15th is, wasn't even there. Wasn't even there. Then has overnight to think about it, and on July 16th, changes it to something else, because it'll make much more sense. Because now she knows a little bit about what they have there. She wants to now be able to say that she was there. But what does she do? She says, not just that she was there, but she makes herself the hero. Just switching it up. Not only does she say that she was there, but she makes herself the hero. in the sense that she pushes the woman down and has the gun pointed to her head, and by luck is not killed, but she's able to push people aside, and then she wraps it up by saying, I wish I could have stayed there. I should have fought more. I did fight, but I should have fought more. And then away I went. Again, trying to paint herself, not only that she was there, but again that she was this hero, attempting to not only tell a different story, but to manipulate that story to make her look better. Years go by, and then we have the story that we have now. This non-stop litany of lies by the defendant just does not stop. She has lied to various groups of people. She has lied, as we said, to you. She has lied to the medical health care professionals. She's lied to the police. And she's even lied to the media, something that she has craved. This individual here craves the media, loves the media, went on national television to talk about this. And what did she do? Not only did she lie to them, but she made herself seem like such a calm person. I wouldn't do that. Didn't tell any of the things that we see here today. And of course, it's not a confessional when you go there, but it is demonstrative of the fact that she's a chameleon, and she'll adjust to the situation and make up whatever stories are appropriate for her at the time, whether it be the media or somebody else. The same can be said is true about her friends, the people that she has, the friendships that she has. She lies to them, and she does things that almost make you step back and say, what could you possibly gain by that? When, for example, she talks to Leslie Jodi and makes up this thing about her kids and Mr. Alexander's kids playing together. She didn't have to go that far. The point I'm trying to make is that these lies are lies, but then she goes even further with them just to sell them, to manipulate the person into thinking that they are actually true. For example, with Leslie Jodi, she could have just said, I speak to Travis every now and then, but then she adds, but I want our kids to play together. When Dan Freeman called her, well, she didn't have to, after he called her and said, I don't know, what happened, but Travis is dead, she didn't have to then go and talk to the bishop. She does these things because she's such an ornate liar. It just has to add the extras to it to really sell it. And that's what she did for you. For all of those times, all of those days that she testified to you. And the reason that I bring that up, this ornate storytelling, is because it applies to her defense and her defense really is based on lies. It really is. And if you can say, for example, she presented it as if it was in self-defense, but not only did she present it as if it were in self-defense, she added some ornate lies to it. For example, one of the things that she added was this physical violence that supposedly Mr. Alexander inflicted upon her. But she doesn't just say that he inflicted these 4 incidents of violence. She goes into great detail about it. For example, she talks about the one in August of 2007 where he goes upstairs and he's banging his head up against the wall, just very flowery, very out there, because then she's again the center of attention. She's being the calm one. She's being the person that is the individual that you would look to for the answers. It's not just the lies. She's a very good liar, but she, on top of that, is a very sophisticated liar in the sense that she adds these extra elements to it. And she did that with regard to the acts of domestic violence. And they are lies. If we are to look at her journals and sit back and take a look at what she writes, those journals tell you that there were no acts of domestic violence. Have you been given any reason whatsoever, other than this law of attraction, and other than another Alice Laviolette, somebody who has trouble with the truth, other than that, vouching for them, do you have any reason to doubt what is being written there? Do you have anything that the defendant has said that has corroborated in terms of the domestic violence? You have the journal entries indicating that they did not happen. You have friends indicating that they never saw it. You don't have any medical reports, any police reports. You don't have anything. And as we get talking about these, there are lies, and then there are monumental, huge lies. And she made this up because that fit her defense. And one of the other things that she did with regard to this is that not only did she make up this lie for her defense, the other thing that she did is that she created a lie that really involves behavior that is a hot button kind of topic. How horrific it is to be accused falsely of being a pedophile. He's not here. He's not here to say, no, that's not true. She can say to Alice Laviolette that it was on the computer, the images, but then Alice Laviolette comes in and says, no, that's not what she told me. But remember, Alice Laviolette has a problem with the truth. And so State goes to the computer and doesn't find anything there. Oh, no, I changed my mind. It was actually images. They were like this. And how does one defend that when there are no images there? The police looked through the attic. The police looked everywhere. How absolutely hateful. And how does one defend that when there are no images there? The police looked through the attic. The police looked everywhere. How absolutely hateful that allegation is, and how absolutely extensive she was with it. But remember I said that she went a little too far with these lies? First of all, her journal indicates that there wasn't such an event. Second of all, the text messages also indicate the same thing. And what human being, if that is the allegation, if they really are caring, what human being doesn't go to the police and say, or somebody else, this person is. What she does, well, it's the new approach. It's the new, and she talks about all these phone calls going back and forth, and that also doesn't match. What she does, well, it's the new approach. It's the new approach to pedophilia. What does she do? Well, let's jump in the sack. That's what we're going to do. At least that's what she tells you now. But with regard to Alice Laviolette, no, she didn't. She can't even keep that together. If that is the truth, and if that is what happened, wouldn't you expect that her journal, if she had it, if she didn't write about it, at least wouldn't have said that nothing noteworthy. It's fortunate that the police did have Mr. Alexander's laptop, and there weren't any images of children on it. None whatsoever. It's fortunate that the police did have Mr. Alexander's laptop, and there weren't any images of children on it. None whatsoever. They checked throughout the house. There was nothing inside of the house that indicated anything like that. There weren't any photographs. There wasn't anything. And so this allegation of hers, whether it was on the computer or whether it was in photograph form, just went a little bit too far. These lies to take from Mr. Alexander, the only thing that he has left, his reputation, it's just a little bit too much to, in light of what we know, in light of what she says, it's just too much even in this particular. That person does not deserve justice. That person doesn't deserve anything because of what he did. It's so easy for her to make these allegations. That person does not deserve justice. That person doesn't deserve anything because of what he did. It's so easy for her to make these allegations. It's so easy for her to get on the witness stand, as you've seen, and lie. And this is really the pinnacle. It doesn't get any higher or worse or lower, whatever way you want to look at it, than that. Well, how do you judge that allegation? Well, the judge has. How do you judge these sorts of allegations? Well, just like everything in this case, there are rules. And those rules are the jury instructions, such as the ones that have been read to you today. And one jury instruction particularly deals with this aspect. Witness's instruction. I know the judge has read it, but because it's so important, it is worth my referencing it because it directly relates his instruction. I know the judge has read it, but because it's so important, it is worth my referencing it because it directly relates to the two primary allegations in this case, that of physical abuse and the fact that Mr. Alexander was interested in little boys and girls, according to her. It tells you that in deciding the facts of this case, you should consider what testimony to accept and what to reject. What it's telling you there is that you ultimately decide whether or not this person here, who is the epitome of a liar, whether this individual, whether you're going to accept or reject what she tells you. Are you going to pick and choose some things of what she says and then accept some other things? How is it that you can know with any certainty whatsoever whether or not she's telling the truth about anything? It says you may accept everything a witness says, or part of it, or none of it. The state submits to you that you are, based on what you've seen, based on what you've heard, and based on the testimony of others, you should accept none of it. It doesn't mean that the 18 days that she was on the witness stand are wasted. No. What that means is that you're finally able to see this individual in the light of day. You're able to see how she reacts. Doesn't matter where. And this instruction then goes on and says, in evaluating testing every one of you in the eye and lie. Doesn't matter where. And this instruction then goes on and says, in evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life. Important matters. What kind of has lied to them consistently about major aspects of their life? No, people will not go to a doctor who lies to them. And the factors that you are to consider are the witness's ability to see or hear. No, people will not go to a doctor who lies to them. And the factors that you are to consider are the witness's ability to see or hear. The quality of her memory is incredible. Absolutely incredible. She was there. She knows. The quality of the witness's memory. The quality of her memory is incredible. Absolutely incredible. Down to follicles of hair. Unless it hurts her. Then the fog rolls in. Then there's an excuse. Then there's a reason why she doesn't remember. She has an incredible memory, all right, when it comes to lying. And the witness's manner while testifying, how it was that she testified, how it was that the defendant testified. Well, you saw her at times attempt to cry. You saw her at times get angry, to somehow make the person that was asking the questions the villain. Saying, well, you're scrambling my brain. It's not my fault. Again, it's not my fault. It's the fact that you're asking me these questions, just like Travis. That's exactly what's going on here. So that's not my fault that I keep lying here on the witness stand. It's yours. Because of the way you're asking me the questions, the fact that you're raising your voice. That's whose fault it is. And that's why I can snap at you from the witness stand. I can smirk at you from the witness stand and look knowingly towards the jury, because not her fault. It's the person who's asking the questions. Whether or not the witness had a motive, bias, or prejudice, if there is any witness in this case who had a motive to lie, it's this defendant. She's the person that's charged. All of the other witnesses that came here, some of them had a motive. For example, Alice Laviolette, she had a motive to lie. I mean, maybe perhaps it was her reputation that she was interested in, or things like that. All the other individuals, for example, Ryan Burns, why would he want to lie about anything? He lives in Utah. He just met her at one time. There's no reason to believe that he was going to be making these things up. Amanda Webb, why would she want to come in here after all the work that she's done and make things up? The only person with a motive is the defendant. So when evaluating her testimony, that's something that you need to consider. when it's to her benefit, she's going to lie. Whether the witness, the defendant, was contradicted by anything the witness said or wrote before trial. Well, she wrote, for example, in terms of these two allegations involving the pedophilia and involving the domestic violence, that they didn't happen. Additionally, she never told anybody. And the reports out there, if there aren't any reports that would corroborate what she said. So, in terms of the pedophilia, well, she says it was on the computer. Well, the computer doesn't show that. And they even went back and looked and traced and looked everywhere. The house, there was no implements, if you will, or anything associated with that kind of conduct. And so in this case, nothing supports what the defendant said. And then you're asked to take a look at the reasonableness of her testimony in light of the other evidence. In order for her to prevail in this case, in order for you to believe her, because it actually comes down to whether or not you believe her. If you believe her, then certainly you can apply the jury instructions. But it comes down to whether or not you believe her. The other evidence, all of the other evidence that's out there, contradicts her. So you have to go against all of the evidence that's out there, turn your back on all of that, and say, I believe her, therefore I'm going to find in her favor. The state submits to you that, in light of everything, that's not something that you should do. So what standard do you apply? Well, the standard that you apply is the burden of proof instruction, which tells you proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. Firmly convinced is the term. It's not any of the other terms that you may have heard anywhere else in life. It's just firmly convinced. And it does tell you there are very few things in this world that we know with absolute certainty. So absolute certainty is not required. And it does say in criminal law that the law does not require proof that overcomes every doubt. That's not what we're talking about here. You just need to be firmly convinced. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. That's how it reads, and that's the procedure that you indicated that you would follow should you be chosen to go back there to resolve this case. Once you make that inquiry, and once you find the defendant guilty, that's the end of the inquiry. The other language that falls after that involves you finding reasonable doubt. But if you find, based on your consideration of the evidence, that you are firmly convinced, that's the end of the inquiry. You don't need to go any further. And there is only one charge in this case. And the charge is first-degree murder. And first-degree murder can be committed in one of two ways. Obviously, you know this, that there is not two charges of first-degree murder. There is only one. But there are different ways in which these can be committed. First is premeditated murder, or second is felony murder. With regard to felony murder, with regard to premeditated murder, there are lesser included offenses, as the jury instructions have told you. There are other offenses, not necessarily lesser, but other offenses that are involved. With regard to felony murder, there are no lesser included offenses. So, for example, if you are considering felony murder, there are no other offenses that are to be considered. The only issue with regard to felony murder is whether or not, in the course of a felony, she killed him. That's basically what the law says. And if you find that, that's the end of the inquiry. You don't consider lesser included offenses. Premeditated murder does have these lesser offenses. But in terms of the tabulation that takes place at the end, for example, 9 of you could find that this was premeditated murder, 3 of you could find that this was felony murder, and it's still first-degree murder. You do not have to be unanimous as to the theory involving the murder. Or you could be 6 and 6, or it could be 12 for premeditated murder and 12 for felony murder. It's still only one charge, You do not have to be unanimous as to the theory of the crime. And let's talk about premeditated murder. Well, it requires that it be proven that the defendant caused the death of another person. Well, exhibit number 207, he's dead. That element is proven. Well, the defendant intended or knew that she would cause the death of another person. That's also proven. One of the things that we know in this particular case is that, amongst other things, she slit his throat, she stabbed him in the heart, and we also know that she shot him. There are 3 different ways that she killed him. So, did she intend? Sure. Did she know? Absolutely knew. Remember, I was talking about how directed it was to the throat. If you do that, then you know, anybody knows, that if you do that to the neck, you're going to kill somebody. So she both intended it or knew. In other words, it could be either or. In this case, she knew. And also intended it based on what we see in this particular case. So those elements are satisfied in this case. There is no doubt about that those 2 elements are satisfied. Now the issue is whether or not she acted with premeditation. And premeditation means that a defendant intended to kill another human being, and then there's the disjunctive or knew. It doesn't say the defendant intended to kill another human being, and then it stops. It says intended to kill another human being or knew she would kill another human being. That is the element that's above in number 2. She knew that she was going to kill him. There's 3 different ways that she killed him. One of those 3 satisfies this, knew she would cause the death of another person. And after forming that knowledge, after knowing that she was going to kill him, because it talks about intending or knowledge, after knowing that she was going to kill him, because it talks about intending or knowledge after knowing, after forming that intent or knowledge reflected on the decision before killing. And the key here is, what is reflection? What does that mean? And it defines it for you. It tells you that it is this reflection regardless of the length of time in which it occurs. That distinguishes first-degree murder from second-degree murder. What that is telling you is that you don't even have to have a day between the thinking and the knowing. You just have to have a length of time regardless of the length. So it can be very short. It can be as short as stabbing him in the shower, and then after a couple of minutes, it can be very short. It can be as short as stabbing him in the shower, and then after a couple of minutes, chasing him down and going for the throat. No one can dispute that he walked that way to get away from her. No one can dispute that he was already injured. He was already going to die. When this was applied, by this I mean the strike to the throat, she knew he was already going to die, but that type of injury indicates you want that person to die. Additionally, when she shot him in the head, although reflection is not necessarily prolonged. Again, it's telling you it doesn't have to be days, it doesn't have to be hours, it doesn't even have to be minutes. And then it tells you in the space and time between the intent or knowledge to kill and the act of killing may be very short. In this case, I guess it depends on who you ask, knowledge to kill and the act of killing may be very short. In this case, I guess it depends on who you ask, this was a long period of time for Mr. Alexander to be going through this. Just a long period of time between the stab wounds to the heart and the shower when he was defenseless to the time that he was trying to get away and going along the wall and absolutely falling down. So in this case, it can be very short. She killed him 3 different ways. She knew that she was going to kill him. Additionally, not only that, she brought the implements. She brought the gun. If she didn't bring the gun and it was Mr. Alexander's, did she have his permission to take that gun? According to her, it was his gun. If she took his gun, then that's a burglary. And if during the burglary somebody dies, i.e. stealing the gun, if she took his gun, then that's a burglary. And if during the burglary somebody dies, i.e. stealing the gun, then that's premeditated murder. Either way you look at it. But we'll talk about that in a little bit more. And an act is not done with premeditation if it is the instant effect or a sudden quarrel or heat of passion. How do you know if it was or wasn't the instant effect of a sudden quarrel or heat of passion? Well, you can take a look at some of the photographs that we have, and they will tell you that it wasn't the instant effect of a sudden quarrel or heat of passion. 160 tells you, does that guy look like he's ready to fight? Somebody who is telling us that. A liar who was dressed at the time. A liar who was poised to strike. If she didn't have a plan, why does she have her clothes on? Why does she need to have her clothes on? And why is it that the gun is with her? She says, oh no, the gun belonged to Mr. Alexander. But if you remember on June 10th of 2008, she called unsolicited to this police officer and said to him, oh no, Travis never had a gun. Travis never had a gun. The only thing that he had were his fists. So, yeah, and you have that on tape. There is no doubt that she said it. In fact, there is a tape that says, Jodi Arias' number is whatever it was, and you heard her voice. And you also heard her saying, he did not have a gun. At that time of the investigation, she didn't know how important it was going to be. She didn't know what lies she was going to be telling in the future. She said he did not have a gun. So if he didn't have a gun, she brought it. And you know that she did bring it. You know about the supposed burglary of her grandparents' house. And so she says that in order for you to believe that this was a sudden quarrel or heat of passion, you have to say to yourself, well, you know, she called the police on her own and she lied to him, but since she's been such a liar and she lied to us in this courtroom, I'm now going to decide to believe her when she makes up a story and says, oh, his father gave it to her. And in addition to that, I'm going to have to believe that the shooting did not occur in the closet as she told Alice LaViolette. Because that's what she told Alice LaViolette, the person who took this hit. Isn't that what she told Alice LaViolette? Do you remember what Alice LaViolette testified? That's what she told her. And in fact, there was a recording of the conversation between the prosecutor and her at an interview that took place in November of last year, in which you heard her say, oh yeah, she told me that the shooting happened in the closet. You're going to have to disregard all of that so that you can even get to the sudden quarrel or heat of passion. That's the problem for the defendant. Are you going to be willing to do that? Especially when the police have looked in that place and there wasn't anything indicating that there were any bullets there. There's nothing to indicate that he had any cleaning supplies. Nothing to indicate that there was a gun. The other thing that is problematic, that it would allow you to reach that, is the shelves. You would have to, you know the shelves, you've seen what the shelves look like, those shelves that were in the corner, and by her own admission, she stepped on the second shelf as she was going to get the gun. You saw what happens to those shelves when you put a little bit of pressure. They move down this way. And you saw the photographs. There was nothing that was the shoes that were there. There was nothing that looked that there had been any activity there. Everything, the photographs, the forensic evidence, her statement says that there was no sudden quarrel or heat of passion because she brought the gun. You would have to, again, throw aside everything else she has said to find that there was an instant effect, a sudden quarrel or heat of passion in this case. What do you want to do as you sit back and deliberate? What do you want to do with one of the first conversations that she ever has with the police before she knows what the issues are and says, he didn't have a gun? What possible reason or justification can she give you to say, at that time, I lied to him? Why? Well, she said before, well, I was afraid initially. She said when she spoke to the officer back on July 15th. That's why I made that first story. Then the second story, well, I was trying to not get in trouble. But those weren't present. Those reasons were not present on June 10th of 2008 when she called this detective unsolicited to talk. It's because she wanted to learn about what the police knew so that she could incorporate it in her story should something come up. But with the truth, you ain't got to remember nothing. And she forgot about some things and made that statement involving the gun. And that's problematic for her. It will stay as part of this record, and it will require you to sit back there and listen to that and say, you know what? She was lying there instead of telling the truth there. And that would require you to disregard the fact that a .25 caliber handgun was taken during a supposed burglary of her grandparents' house, and that was the gun that was used to kill her. The issue of the gun will not go away, especially since she said that he didn't have one, especially since she also indicated that there was a circuitous route through the closet, especially when she could have just walked out. The guy's naked. He's not going to run after her outside naked. And then indicating that she came through the closet, shoots him in the closet, according to some accounts, shoots him outside of the closet in the bathroom, and grabs a gun that she believes is unloaded. If she believes the gun is unloaded, what is she going to do with it? Throw it at him? Why stand there with the gun if you know it's unloaded? None of it. Absolutely none of it is true. You could even be charitable and say it doesn't make sense. I'm not asking you to be charitable. It's an absolute lie of this issue about the gun. She said it, and she is wedded to it. I won't even discuss the lesser included offenses because of the issue involving the gun. She brought it herself. Felony murder requires the state to prove two things. The first one is that the defendant committed or attempted to commit a burglary in the second degree. What is a burglary in the second degree? And notice it says attempted or committed the burglary. The crime of burglary in the second degree requires the defendant, in this case, to enter or remain unlawfully in or on a residential structure. We don't know if she was invited in. We really don't know if she was invited in at all. So, but did she remain unlawfully? I think it's not a stretch to say that an individual who owns a home and is being stabbed to death, that the person that's doing the stabbing there no longer is entitled to remain lawfully in that house. No, I may be charitable, I may be a nice guy, but you know what? If you start stabbing me, you're no longer here lawfully. That consent to come in is no longer there. If you keep stabbing me, that's it. It is not a stretch of the imagination to say that. And we understand, the state understands that Mr. Alexander is not here to say, I revoked my consent. But if he's being stabbed, if he's having his throat slashed, and if he's being shot, it is not a stretch to say, based on circumstantial evidence, to say that she remained unlawfully. So she has remained there unlawfully. Is it a residential structure? It absolutely is. So that's his house. And she did so with the intent to commit any theft. Well, at some point she stole the gun, according to her, or a felony therein. You can bet that stabbing somebody is a felony. So he doesn't want you to be there, and you're stabbing him, and you're killing him. That's a felony. So the elements of burglary have been satisfied. So we go back to the first prong, and it says the defendant committed or attempted to commit burglary in the second degree. Yes, he did accomplish the burglary. So that element is satisfied. Number two, in the course and furtherance of committing this burglary that we know that she committed, or immediate flight from it, in other words, she took off and she took his gun. So that's the theft right there. And as part of that, even if it wasn't her fault, the defendant caused the death of another person. If you are committing...
Objection, this states the law.
Overruled.
The defendant caused the death of another person. And she did cause the death of Mr. Alexander during this burglary. She took off, and she took off with his gun after stabbing him. So she has committed murder in the first degree under both theories. It isn't just one theory that she has committed this crime under. And so now you're left with the decision that you have to make. The one admonition that I leave you with is that these jury instructions are not advisory. They are mandatory. And it's a situation where you go back there and you read them. And as you sit back and you decide this case and you attempt to reconcile the lies with what actually happened, keep in mind that the defendant has attempted to manipulate you, has attempted to paint the picture for you. For example, something like this. This is what she wants you to believe. Something like that. There's Mr. Alexander and her. That's what she wants you to think. That's what the feeling that she wants you to have. But actually, reality is this. That's really what we're talking about in this case. That's his back, not his throat, but you've seen his throat already. And that's really the reality in this case. And as you consider this case, and as you ponder your decision, one of the things that I want you to consider that is symbolic of this whole case is that this issue involving the gas cans. What she wants you to do, because you know it's a lie, what she wants you to do is disregard it. But symbolically speaking, when she asks you to disregard it, what she wants you to do is she wants you to carry those gas cans for her. She wants you to help her fill them with gas. That's what she wants you to do, symbolically speaking. What the state is asking you to do is to not leave this courtroom filled with the stench of gasoline on your hands. That's what we are asking you to do, because it's not true. But she's already talked to you about these gas cans. It's not true that she returned them, but she's asking you to help her. She's asking you symbolically, help her by carrying them out and taking those cans with you. What the state is asking you to do is your duty. And the judge has indicated that your duty is to follow the law as she's given it to you and apply it to the facts. And in asking that, the state is asking you that you return a verdict of guilty, and that you return a verdict of guilty as to first-degree murder. Not only as premeditated murder, but also as to felony murder. For no other reason that it's your duty and the facts and the law support it. Thank you.
All right, ladies and gentlemen, we were here late last evening, so we are going to adjourn for the evening now. Please be back tomorrow morning. We will start promptly at 9 o'clock. Please remember the admonition. Are there any questions? You are excused. Have a nice evening.
Please stand for the jury.
We are in recess.